Yeah, my lord.
Yes.
My lord, I beg to mention item number 4, my lord.
Item number.
My lord, leading counsel is on leave. So matter may be adjourned for today, my lord.
Let us see. Item 4. No steps. No steps.
Sorry, my lord.
No steps have been taken upon the respondent number 6 to 11
Yes, my lord.
since November 2024.
Yes, my lord.
4 months. Are you not interested or what?
No, actually, my lord,
You are in the set of lawyers or not?
sorry, my lord.
Your name, please.
NUP. I put a petitioner, my lord.
Yes. Is he? The set of lawyers. No.
Your name is not there.
No,
Are you in the case?
no, my lord. Since my lord, leading counsel, Mr. C. Modi is already on leave, so my lord.
Okay, but there are about 7 other councils.
They are not available.
All 8 of them are absent.
Yes, my lord. They are not available today.
Huh? All 8 are absent. Good. On the prayer of Mr.
NUP, my lord.
Learned Counsel appearing for Mr. C. Modi, Learned Counsel for the appellant. Matter stands adjourned for a week. Full stop. It is noticed that by an order dated 4/11/2024, the appellant was asked to take steps for service of notice upon the respondent number 6 to 11 by registered post with AD as well as by usual process within a period of 3 days from 4/11/2024 full stop as part office note dated 21/4/2025, no steps have been taken on behalf of the appellants for service of notice upon the respondent number 6 to 11 till date. Full stop. On the next stage of listing, the appellant is to explain the reason for not taking the steps.
All right.
Lordship, I beg to mention item number 5, Lordship.
Yes,
Lordship,
for the appellant,
Lordship, I'm for appellants. Lordship.
legal aid counsel.
Lordship.
I am for the respondent, your lordship, for the state, your lordship.
Yes.
Lordship, I have a personal difficulties with this, Lordship. Yeah.
Okay. When?
Lordship, can it be after 2 weeks?
After 2 weeks, your lordship.
Mr. J. Genie,
Lordship.
learned legal aid counsel, has made a prayer for adjournment on the ground of his personal difficulty, as sought for and as agreed to by Mr. as sought for by Mr. Genie and as agreed to by Mr.
Theater.
Learned additional public prosecutor leads the appeal after a week on a date which is by the office.
Okay.
After 2 weeks.
Yes, your
After 2
lordship.
weeks.
Deeply obliged.
Yes. Board presentation. Issue notice. Beyond the order. Is executed. A state judgment and order, single judge. Okay, period of solution. Where will counsel. And adjournment. And it's adjourned. None appears. Last date, none appears. What is the matter of this? Tender. You procure, you should wait. Oh. Yes, any update, up to date instruction? Notice E procurement.
My lord, in my case, RW did only when the road was in dilapidated condition, RWD constructed the road. So now they come against the construction of road.
E-procurement notice 22/6/2020.
Yes.
Issue for construction of so and so, maintains there about 5 years. It is about to be 5 years. 2020.
Yes.
Works are completed.
Yes.
They're going to pay their land.
Actually,
company.
this road construction was only portion of highway which was diverted.
Now, who are the appellants? Why they are
Appellants-
making a prayer for to pay land compensation?
That is against highway.
Huh? Send your proposal to the village. Application were to be acquired for the construction of the. And the learner revision high along the. Alternative alignment was adopted for CD to Park Road. The villages of the petitioners which lie along the old Weir Road were excluded. One is the second is land compensation because land wasn't no question paying compensation. And I think it's not that. It doesn't mean yes. And now they were is in the prayer. To construct two land. That cannot be. Maybe if two land is constructed, they may give entitled for a. Which is the reason there. But if diversion is approved, yeah, when is this? Maybe, yeah. Yes, you are for?
Your Lordship, I'm appearing for 2, 3 and 7.
2, 3, and 7.
Yes.
I am referring to 1, 4, 5, and 6. RWD.
Okay. This one non-prosecution. This one non-prosecution. Here that somebody was there.
May I, Your Lordship? Your Lordship, this is for the second time the petitioner counsel is absent.
Yes.
Maybe they are not, no more interested. in the case.
There is no representation on behalf of the appellants press petitioners. Today on call, Mr.
G. Tarak,
G. Tara, learned
standing counsel for RWD.
standing counsel,
For RWD, Rural Work.
PWD.
Rural Work Department, RWD.
RW. Okay, RWD,
WD.
D,
D.
for the respond number
1, 4, 5, and 6.
1, 4, 5, and 6, and Miss
P. Sangeeta. P. Sangeeta.
P. Sangita, learned counsel for the respond number.
2, 3, and 7.
Okay, your standing counsel PWD,
Junior governor.
junior government, okay, for the respond number 2,
2, 3, and 7.
7 are present. Full stop. It is found that the learned counsel for the appellants, the state petitioners, were absent when the appeal was previously listed on 12/3/2025. Full stop. Finding their absence, this court ordered to list the appeal again after a week. Full stop. Therefore, when the matter is listed today, the learned counsel for the appellants, the state petitioners, are found absent. Full stop. In view of the same, this court is of the view that the appellants, the state petitioners, are not interested to pursue the intra-court appeal. Full stop. This court is therefore of the view that the appeal, intra-court appeal, is to be dismissed for non-prosecution, and it is accordingly observed. Yes, sir.
Your Lordship, I am seeking for an adjournment, Your Lordship, here.
Yes, the appellant,
Lordship,
if it is a forest land,
Lordship, forest land. Now, all these issues, they raise their issues in while filing the affidavit only, Lordship. And the claiming of forest land is in respect of my allotment only, Lordship. As Lordship aware, entire capital region, Itanagar, if these notifications are ineffective,
not only your case, I think private respondents' case have been also
Private-
negated, is it not?
yes,
Let's go
now
directed.
now raising this issue on now only, Lordship. My allotment was cancelled. On what ground, Lordship? They cancelled my allotment, saying that the land has to be allotted to the BJP.
That is also cancelled.
Yes, that is subsequently cancelled.
Now,
No,
broad issue is
May I please?
whether a forest land can be allotted without
Yes.
following the procedures of Forest Conservation Act.
NOC, Lordship, we have already obtained the NOC from Forest Department and it was placed
Question
before.
is Forest Conservation Act and Indian Forest Act. The broad issue is that only. Thereafter, the question of allotment in forest conservation. Which act, forest act is applied? Assam Forest Regulation? Or
Assam Forest,
1997?
Assam Forest.
Once it is notified, nothing is permissible. And when it was notified, as per the single judge,
Lordship,
when? That single judge has observed
yes, page,
somewhere,
page number 04, Lordship.
204, paragraph,
Paragraph, Lordship, operative person is at 217,
paragraph.
24, Lordship. Now,
Paragraph 19.
Lordship,
Materials brought on record in the affidavit in opposition filed by the respondents goes to reveal that Itanagar Reserve Forest was notified by notification dated 20/2/1978. And thereafter, the area falling under Itanagar Reserve Forest was so notified as a sanctuary by order dated 14/6/1978.
yes, Lordship.
The said position continues
Continues
to
to
hold the field till date. Can you negate it?
Lordship,
If this is the fact,
this might be fact, but Lordship, this affidavit. Now, Lordship, allotment, entire
any
allot,
notification is annexed in the affidavit in opposition. So us, where is the affidavit in opposition?
affidavit in opposition, Lordship.
Copies of 153. 153.
153, Lordship,
Hmm.
is the affidavit filed by the Deputy Commissioner.
Is it there?
Yes, Lordship.
It is not. It is there, 168. Assam Forest Regulation. Page 177. Forest Conservation Act.
177
Conservation
also.
Assam Forest Regulation.
Volume 1. Volume 1.
Assam Forest Conservation Act doesn't it? Forest Conservation Act. Forest Conservation.
Assam Forest is volume 1. Volume 1, Arunachal Court.
Section 17. Section 17. From the date as fixed, such forest shall be deemed to be a reserve forest. Now, section 21. No right of any description shall be acquired in or over a reserve forest except by succession or under grant or contract in writing made by or with the previous sanction of the state government or some person in whom such rights or power to create such right was vested when the notification under section 17 was published. So you have some previous, you should have previous right. There was no right. So no rights of any description shall be acquired. It is as simple as that. Your allotment is cancelled as well as the single judge directed to cancel the allotment in respect of the other two.
Yes.
Response number 6 and 7. That is why they are not interested, because they know they are right.
But here, Lordship, the one of my ground is if this act has to be applied, it has to be applied in total, Lordship, in entire Itanagar area, Lordship, within Capital Bridge.
You cannot claim negative equality.
Including Tara's land, Tara's mansion, Mr. Tara's mansion.
Is it under Itanagar forest?
Even the Secretariat office, entire office, Lordship, they are constructed within this notified area. But this is only in my case, they brought this
That
notification.
is negative equality.
Yes, that is.
So was positive equality under Article 14.
Yes.
Is the fact that Itanagar forest has been notified in 1978 and thereafter it has been declared as a sanctuary. Section 17, Section 21 of the forest regulation comes in. And law is settled.
Yes.
If it is declared, then there cannot be any right unless you have some other rights at the time of notification of the forest. When you were born, Itanagar Club was born when?
82. Lordship.
1982.
Yes. Prior to it.
Your birth was after the forest. So there is no right. You seek allotment somewhere else.
Lordship, can it be fixed on next week, Lordship?
Not next week.
I will take,
You take
I will have some discussion.
day after tomorrow. To us, if you have any right,
Lordship.
positive right. Otherwise, they. Yes, sir. Section 22, there are so many decisions. You cannot put out anything. You are a citizen of the right here. That is why we are trying to seek some problem. They do not come there. Let me also cancel this. They do not come here. The new idea, I got the position multi-party, but after that, I need to know that the forest will be of no point in making the example is but not in forest. Exactly. Okay. Yes.
Right from defense. Government has given development to the defense also. And all the paramilitary forces. And here in this capital, this 11 square kilometer of the land is only available for the state government to establish the capital. And thereafter, not going to happen. In between, even our present high court where we are constructing, it also comes in the reserve forest. So now what happens?
We'll go also.
Many of us. But what happened here?
Mr. Tara,
I'm pressing for.
the reservation is not our, is not within our domain.
I'm trying this is the code for one particular reason, only to make a request that why this petition, when this application should be granted some time for a full processing. Is that, rightly or the wrongly, section 17 and 21 of the Assam Forest Regulation Act. Read the 1980 Forest Regulation. It's all about is there, but the state government has committed a wrong. But
Rectification of wrong, the ball is in the court of the state government.
Therefore, just one minute, just and try this. What had happened is, rightly or the wrongly, the forest department also gives a NOC, and the state government has given allotment. And a civil right of the citizens have been created. Suppose tomorrow if the LPC.
You may have civil right, but this petitioner, there was no approval, no final decision. It was in the process, right? So his right was not even crystallized.
Correct. I was thinking go down, but only one perspective I try to apprise the board is rightly or the wrong. Allotment has been given to the federal. A citizen has been reviewed and constructed.
No, Mr. Tara, this petitioner was not given the allotment. Okay? His right was not crystallized. It was in the process of being allotted.
Approval was made by the.
No, ultimately, where is the order? There may be communications between authorities, right? But ultimately, where is the allotment order? Authorities may exchange their views, but ultimately it has to be, there has to be an order of allotment,
Correct.
right?
Approval has been
Approval, but there is, where is the order? Until it is
communicated.
in the form of an order to be communicated, to be made public, it is not an order.
Well, can you give my brothers in time? I request you on behalf of the bar, I request you.
Within a form of a local model. Yeah. In this case, it is not allotted. Yes. And the only difference is, but if you want it, you can transport it after one. Oh. Okay. 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 Yes, when do you want? Next week? Okay. On a prayer, Mr. Learned counsel for the appellant. Lays the case after a week. As the prayer is consented to by Mr.
Why did I
Learned State Counsel.
Yes.
Number 3.
Section 70. 70.
70.
Hmm.
Though I was approved as a subcontractor, there is no subcontract agreement between the present appellant and the valid contractor, nor there is any contract agreement with the BR. The approval is only with the condition that all principal contractor. Now, my claim is that my construction is by way of a legal sanction. I have been given approval, I have constructed. To the extent of 49%, rather I have done more than 49%. The part 51%, so far as the principal contractor is there, he did not even laid a single stone chips in the road. It is an admitted position. Now, the damage has been sought to be realized from me based on the, my lord, contract agreement between the principal contractor, respondent number 6, and the, my lord, BR. However, my lord, the honorable single judge has not considered that aspect of the matter at all. The entire matter has been, my lord, considered in the light as if, my lord, the subcontractor entered into the shoes of the contractor, and on that basis, relying on various clauses, my lord, partly allowed my lord, writ petition, saying that all the pending bills, whatever is there, that will be given to me directly. Because the BRO was saying that we don't have a contract with the present appellant. So therefore, any payment, whatever, that will be given only to the principal contractor, that is respondent number 6. Court did not accede to that, said, so far as the damage already realized, you go to civil court. So far as work completion certificate that you grant, and all pending bills are to be released in favor of the appellant. Now, my lord, matter was listed on 8, my lord. In the meantime, some further development has taken place. I have submitted the copy of the certified copy there. My interim prayer in the original the appel memo was for extending the authority formula and casing the bank guarantee that was submitted by me.
You submitted the bank guarantee to whom?
It was my money. It was in my name, submitted in the contract agreement, in the contract. That contract is which was allotted to respondent number 6. Even for the
So the bank guarantee is in the name of whom?
is in the name of the present appellant, my lord. It is only he who has applied for extension of the BG, and thereafter that has been extended. It is not the valecher on whose request the BG has been extended. That your lordship may find, my lord, page 79. Clause number 7, your lordship may kindly see. At the request of Petro Dumper Enterprise, we have amend above mentioned bank guarantee as follows. Expiry date of bank guarantee has been amended to 73/2025. It is not on account of the valecher. And in fact, my lord, I have stated in the writ petition that when entire work was not allowed me to execute by way of subcontracting,
No, where is the original award?
my lord,
Who was the
respondent
principal?
number 6, my lord. LOI is at page, lordship.
No, who is the principal means the owner.
Owner is the BRO, my lord, Border Road Organization.
Okay,
Lordship. LOI is in favor of respondent number 7 at page 78.
78.
Lordship.
Construction of Machuta. Drainage. Two-lane with hard shoulder under project. In the state of Maharashtra. This. Tender number central technical. Okay, this is LOA. Then where you coming?
I come at, my lord, at page 88. my lord. Paragraph 3, the proposal has been examined in the light of provision of so-and-so.
Page 88.
Page 88. Lordship may come to page 89, paragraph 3. Clause 4 makes it specific, my lord. That is the only condition of the subcontract. EPC contractor Messrs. Velasa Engineering Limited shall at all times be responsible and liable for all its obligation under the contract. Well, except terminating the contract, they have not taken any recourse against this, my lord, respondent number 6. Rather, my lord, from the various pleading, your lordship will find they have been trying to release this amount to the respondent number 6. My lord, why this undue favor to him, my lord, when admittedly, my lord, I have executed the work, my lord, and he has not done a single, my lord, not a single chips has been laid in the road. That is the only aspect.
You are a subcontractor to the extent of 49% of the value of the project.
And clause 4, that Velasa will be responsible. If I do anything wrong, Velasa will be responsible.
Now you are seeking what? In the
Madam-
writ petition.
In the read petition, there are three things. Lordship will find my read petition at page 32 and the prayer. Page 72. This relief one has been granted by this honorable court.
Respondent number 3.
And there is an interim order passed by this honorable court considering the materials available in record, not to encash this bank guarantee.
To the petitioner for the same project to the extent of. But whether with you being allowed only by this page 88 letter, is it possible for you to claim all this in a writ petition?
No, that's what based on section 70. There are three ingredients I have to satisfy: that I have done the work lawfully, I have discharged my part, and they are enjoying the benefit of the service I have rendered, so they are liable to pay.
What has been held by Supreme Court in Ganga Enterprise or something like that?
But there, Ganga.
Do you have the judgment?
Yes, yes, my lord.
Let us see.
Not that Ganga, my lord. There's a caton of judgment, my lord,
No,
which
get
also referred, my lord.
about the subcontract. Rights of a subcontractor under a principal contractor with the authority.
Lordship. Now here, my lord,
Is it Ganga is available?
that is not available with me. I'll check it up, my lord. But here the distinction is that
I paid to a salon.
here, my lord,
I paid to a salon.
distinction is that though the word subcontract has been mentioned, there is no subcontracting agreement with me and the respondent number 6. They have not scrutinized whether we have a subcontract or not. Number one. Secondly, the approval letter your lordship has seen that all the responsibility will be with the principal contractor. Now, materials available in record, it is clear that the principal contractor has not done a single portion of the work. Whatever done is done by me.
Is there any completion certificate?
My lord.
Is there any completion certificate?
That's what, my lord, there is one of the prayer that the portion, the amount of work I have done, you should issue a completion certificate, which has been granted by the Honorable Single Judge. Now they have, my lord, misrepresented before the Honorable Single Judge that I have done only to the extent of 26%. But this was, my lord, with reference to the date of 27th April 2023. Now in a letter they have come up saying that it is 40% of work I have executed. But my claim is that I have done more than 49%. Because 20% of the a portion of the road. Because a stretch of the road, measuring about 1.25 kilometer was not approved for construction, and which, my lord, bears about 20 crores of rupees. So principal amount, though it is 67, this, my lord, 20 crore has to be deducted, my lord, from it, my lord. And this, my lord, not handing over has not been denied by, my lord, the BRA.
But termination notice, it was terminated
Terminated,
on 16 December 2023.
Lordship. I have done my
And
complete.
as per the authority, it is, the progress was only 26.21%.
That's what. From the record itself, it will appear, my lord, it was as on 27/4/2023. Now in a subsequent letter, which is part of the, my lord, miscellaneous application, they admit to the extent of 40 point some percentage. My lord, for the fault of the principal contractor who did not execute a single portion of the work of the 51%, but I have been penalized. The objective of the, my lord, insertion of this particular clause of 4.20 of subcontracting is only to, my lord, generate employment for the local contractors, small contractors, so that they can be experienced by entering into this clause. And thereafter, my lord, they can be, my lord, eligible for, my lord, executing, my lord, larger the work, my lord, of larger amount.
No, you're entering into arrangement with the principal contractor.
Lordship. I don't have, my lord, any contract with him. There was an, my lord, MOU prior to submission of the tender to say that tender will be submitted on his in the name of Velesa. If he is successful, in that case, back-to-back entire work will be allotted to me. But on, my lord, this 49% having been granted, I have approached the authority. I said that you allow me to withdraw this bank guarantee, because that amount has been deposited with the expectation that entire work to be executed by me. And the authority has said, since you are 49 to the extent of 49%, so after completion only that can be released to you. And for the remaining, they'll go to Velasa, etc. So that's how, my lord, my amount has been stuck. There's no impediment for them, my lord, the BRO, my lord, it's a mighty organization. They can.
No, that is not the issue.
Lordship.
Just because someone is mighty,
Lordship.
that is not the issue. What are the reliefs granted in the
Lordship,
petition?
Lordship, page 530 is the judgment. Page 544 would be relevant, the relief that has been given.
Now, with what grievance you have come in this intra-court appeal?
Page 54, my lord. Is the relief granted, my lord? Page 54,
544.
my lord.
544.
44, lordship. Paragraph 24.
Huh?
The three reliefs that
Yes.
lordship. The first relief I am not aggrieved. The court has granted that to the extent of work I have done, will execute, will give the completion certificate. So far as the 2 is concerned, against which I am aggrieved. So far as 3 is concerned, my lord, I am not aggrieved. Because all pending bills, if not paid in the meantime, shall be released in favor of the petitioner in terms of joint verification. 2 is that, my lord, in respect of the issue liquidated damage compensation and releasing of performance bank guarantee, etc., the petitioner shall relegate to seek redress in the appropriate civil court for recovery of the amount for.
Privacy, we are not impressed.
My lord.
The relief granted by the learned single judge
Lordship.
appear privacy to be correct.
Well, the whole, my lord, my case was based on the section 70, but nowhere in the, my lord, judgment your lordship will my lord, see that aspect had been considered. Not at all, my lord. As if, my lord, I have entered into the shoes of the, my lord, principal contractor.
They will issue notice at this stage, then let them come.
Or lordship may admit, because the, my lord, and the fixed date of hearing matter can be disposed of as early as possible, my lord.
Let it be notice be issued.
Lordship.
What the BRO come? You are representing BRO?
Yes, ma'am.
Okay.
For
What do you
response,
say?
everything has been done as per the contract clause. Only allowed to execute the work to the extent of 49% only. To that extent, the payment has also been made. Admittedly, during the course of the pendency of this writ petitions, the bank guarantee, but whatever the amount here deposited on behalf of the principal contractor has been encased by the department. After termination, there is a clause for encasement of the that is the only remedy they left with the department.
Bank guarantee has been encased.
Fine.
No, it is only on 27/3/2025 after the judgment, because there is a stay order passed by this court.
Art, Mr. P.J. Soikia. As senior counsel listed by Ms. M. Nirula. Right. Counsel for the appellant. Appellants. Was also heard Mr.
M. Khato, madam. Mark
M. Khato.
Yes, ma'am.
Understanding counsel.
DSGA, madam.
Deputy Solicitor General of India. For the respond number
1, 2, forward.
1, 2, 3, and 4. And Miss
I'm for respondent number 5, Your Lordship.
Miss
P. Pangu, Your Lordship.
United State Counsel for the respond number 5. So stop. This intra-court appeal is directed against a judgment, an order dated 4/3/2025, passed by the learned single judge in a writ petition, WBC number 3 of 2024. First one. The Lawrence Intelligence has disposed of the writ petition. With the inter alia with the following directions. Para 24. Huh? Mr. Soikiel and Senior Counsel, appealing for the appellants, has submitted that the petty appellants are not aggrieved by the direction given in Roman 1 and Roman 3. However, the appellants are aggrieved by the direction given in Roman 2. Para the subject matter of dispute is a contract, work, quote unquote, construction and upgradation of Teto des Mechuca Road within bracket design chain is from KM 33.100 to KM 41.275 and existing chain is from KM 36.000 to KM 45.410 bracket close to 2-lane with hard shoulders under project Brahmang in the state of Arunachal project on EPC mode. The contract work was short. The contract work was awarded through the respondent number 6 on 15/6/2021. And the LOA was issued in favor of the respondent number 6 on 22/02/2022.
21.
Full stop.
That was 15/6 is the
Subsequent
date
to the
of-
LOA, the petitioner, sorry, appellant number 1 was brought in as a subcontractor by the respondent number 6 in order to execute 49% or execute work to the extent of 49% value of the contract work amounting to rupees 33 crore 23 lakh 67,000 out of the total contract value of rupees 67 crore 83,000.
lakhs.
83 lakhs. Close to. It is the contention of the appellants that the appellants had deposited a bank guarantee of rupees 2 crore
3,49,000.
3,49,000
9,000.
on behalf of the appellant, sorry, respondent number 6, that is the principal contractor, and thereafter proceeded to execute its part of the contract work and had thus become entitled to 49% value of the contract work. Full stop. However, the authority in the respondent BRO cancel the contract by the termination notice dated 16/12/2000 pursuant to a termination notice dated 16/12/2023 on the ground that the contract work was executed only up to the extent of not rupees, 26.21%, which was, and the rate of progress was not satisfactory. Close to. Fair enough. The matter would require consideration. To sublet notice be issued to all the respondents. As Mr. So-and-so has appeared and accepted notice on behalf of the respondent number 1 to 4. And Ms. So-and-so, State Council has appeared and accepted notice on behalf of the respondent number 5. The issuance of formal notice to the said respondents stand dispensed with. The appellants shall take steps for service of notice upon the respondent number 6 and the
Seven.
respondent number 7 by registered post 80 within 3 working days from today. Paragraph likhiko, Mr. So-and-so, Lion Standing Council BRO has submitted that after the judgment and order dated so-and-so, the bank guarantee submitted, bank guarantee amounting to rupees 2 crores so-and-so has been encased.
Man,
Close the matter would be your consideration. Issue notice returnable on. We will fix it. 4 weeks. Say that. Okay. 26 May.
No, sir.
26 May.
I is there, but,
It has been encased, sir.
no, that was my interim relief I was seeking in the appeal memo, but this I have filed for staying the judgment because as per the direction number 3, all the pending bills are to be released to me. Now what they are saying, though joint verification found to be 11 crores or not, now they will deduct all the damages, etc. So they will release only 3 crores or not to me, madam. And if that be so, this requires an interpretation with the clause 2 again, madam. So if this, they deposit, till date they have not deposited the, disbursed the amount of 3 crores. So therefore I'm paying for a stay of the judgment, so the amount cannot be disbursed to my account. Otherwise I have to challenge that again, this letter, which I am annexing with the IA. Again, I have to challenge by way of another petition.
Which one?
I am 112 minute. Page 19. Eleven 20, page 20. In the middle portion, para 24, within bracket small Roman 3.
basically,
24(2), my lord, the clause 24.2 says, my lord, damage deducted. It doesn't say, my lord, to be deducted.
Which clause you are referring to?
My lord,
Which clause? You're referring to some contract clause?
no, my lord. My lord, this relief that has been granted, my lord, 24(2), my lord, in the writ petition. It's page 544, my lord. That 24(2), in respect on the issue of liquidated damages compensation and releasing of the performance bank guarantee. Amount forfeited.
Hmm.
My lord, there's, my lord, we submit from stage to stage the bills, my lord, and therefrom, my lord, they deduct certain amounts with them, my lord. In the name of IPC, etc., my lord, then taxes, etc., something, my lord, that amount it is finally calculated. So those forfeited already amount which has been deducted. So by this, my lord, clause 24(2), for those purpose, we were relegated to the civil code. But the clause 3 clearly says, all pending bills, if not paid in the meantime, be released in favor of the petitioner. Now,
Joint verification report.
Lordship, joint verification.
Now, where is the joint verification?
Joint verification report is at page. There, my lord. At page 444, my lord.
Yes, what is the finding?
Sorry, my lord, sorry, my lord.
What is the finding?
Page 444. 440.
But as per joint verification, the amount, if Malata, basically, petitioner is Malata agreed by the directive number 2, Malata. If Malata, this order is Malata interfere with, Malata amount whatever entitled by the petitioners will be again Malata, again the prejudicial. The department is Malata after joint verification has calculated the amount and it is calculated to the tune of as per the record.
What is the joint verification report finding?
Finally, the
At
joint
page
verification report
444.
is as per report to 3 crore and above is only
No,
entitled by
report is at page
after calculation
444.
everything.
Page 444. It doesn't speak of any amount, my lord. This joint verification report they have done, that also we have not agreed full extent, my lord. Now, out of this, they have calculated this damage portion and they have deducted the damage portion, etc. my lord. Compensation. Lordship may also observe, my lord, any amount disbursed.
Mr. Soikia, you have no valid agreement in the eye of law.
Therefore, is the section 70.
Your structure is on very
Therefore, my lord, section
slippery
70.
ground.
Lordship. Otherwise, I would not have, my lord, be able to come to this.
Maybe the repetition may be not maintainable.
Lordship may at least, my lord, observe that any disbursement that is made pursuant to clause
This is
3
subject to the outcome of the
Lordship.
appeal.
Lordship.
Because the finding it is there and that is also an admitted position. There is no agreement, valid agreement.
Lord, that is the whole thing. Had there been an
Not with
agreement.
the authority and even not with the principal contractor.
Lordship. My lord, had there been an agreement.
And read code will decide what would be the contemplated terms and conditions. This is too difficult. Well, issue notice and
Any disbursement that
any
made.
disbursement will be subject to the outcome. Art, Mr. P.J. Soikia, Lawrence Senior Counsel. Listed by MS and Nirola, right? Counsel for the applicants. appellants and Mr. Sunil Sotul and council for so and so, stroke opposite party, number so and so, and Ms. so and so. Issue notice, returnable on same thing, same steps. Having heard the land council for the parties, it is observed that any disbursement made in terms of the judgment and order dated so and so passed in repetition by the to the applicants appellants will be subject outcome of the connected region. Number six.
Hablas.
Yes,
I beg to mention item number 16, Your Lordship.
16.
Yes, Your Lordship. Here we have to file amended petition, but we have completed the amended petition, but we couldn't swear in the affidavit.
My
So we
lord,
may see-
I'm appearing for respondent in this case, your lord, my lord, if this matter may come up in the regular course list, your lordship. There's some submission to be made, your lordship.
Yes, yes.
If this matter may kindly come up in the regular course list, your lordship.
What is? Huh? Huh? Okay, on its turn. Okay, wait for your turn.
I beg to mention one more item, item number 35. Item number 35,
25.
yes.
Yes.
The arguing council is out of station, so maybe adjourn.
25 is with
35.
24.
35,
35.
35, yes.
Yes. Sunil Mo. Yes. What is your prayer?
Maybe adjourn for some days.
Miss,
As so moved.
who is for the respondents?
I have taken consent.
Okay. Miss so-and-so. Learned counsel appearing for Mr. S. Mo. Learned counsel for the petitioners has made a prayer for adjournment of for a week
Yes,
of the case for a week. As the prayer is made with the consent of the learned counsel for the respondents, the prayer is allowed, lays the case after a week. Relate to his by the office.
much.
May I, my lord? My lord, item number 15.
Yes.
Yes, my lord, in this item, we need some time to file reply, madam. Reason.
Mr.
T. Kamchi,
T. Kamshi, learned counsel for the petition has paid for and is granted. How much time?
2 weeks.
2 weeks time to file an affidavit in reply to the affidavit in opposition filed by the state respondents. Release the case accordingly after 2 weeks.
Much obliged.
By the office.
Mayor, Lordship, I beg to mention item number 23. Lordship, here the matter become infractious, as I may be allowed to withdraw, Lordship.
If it is infractious, okay. Mr.
B type, dear Lordship.
B type, learned counsel for the petitioners has submitted that. You want to withdraw or matter becoming infractious?
Infractious, Lordship.
So if it is infractious, it is to be dismissed.
Lordship.
Subject matter of the petition has become infractious. So, in view of the submission made by Mr. Soinsul and counsel for the petitioners, the petition is dismissed as infractious.
Your Lordship, I beg to mention item number 34.
Yes, sir.
This, I am seeking for adjournment. This matter may be listed after 1 week.
You are for the petitioner?
A respondent, private respondent.
Private respondent. Number? Private respondent number?
4, 5, and 6.
4, 5, 6.
Yes.
Mr.
M. Tasso.
Learned counsel for the respondent number 4, 5, and 6 has made a prayer for adjournment. Post of. It is submitted that consent has been taken from the learned counsel for the petitioners and other respondents to make the prayer. Post of. As sought for, the prayer is allowed, raise the case after the week. On the activity by the arms.
Obliged.
Your Lordship, I beg to mention item number 14. Since
Yes,
my
ma'am.
senior leading counsel is out of station. So the matter must be listed after 2 weeks or 3 weeks.
Okay, on the prayer of Miss
BS, sir.
Learned Counsel appearing from Mr. C. Modi,
Yes, Your Lordship.
Learned Counsel for the petitioner, and lays the case after 3 weeks.
Much obliged.
Yeah, Lordship. Lordship, I beg to mention item number 22.
22.
Yes, Lordship. In this matter, I'm appearing on behalf of Titagum, Tavatagum, Department of Education, Lordship. Lordship, in
Department
this
of
matter-
Education. Okay.
Yes, we need to
Hmm.
file affidavit.
Huh?
We need to file an affidavit, Lordship.
How
For,
much time?
3 weeks, Lordship.
Mr.
Titato.
Learned Counsel appearing for Mr. T. Tagum. You are T. Tagum.
No, Lordship. Titato.
Appearing for Mr. T. Tagum, Learned Standing Counsel, Education Department has paid for and is granted 3 weeks time to file the counter affidavit on behalf of the respondent Education Department authorities. First up, who is the petitioner counsel? Present? No. It is submitted that prayer is made with the consent of the learned counsel for the petitioners.
Obliged, Lordship.
My lord, I beg to mention item number 30.
30.
Yes. We have
Yeah.
taken the consent from the opposite counsel. This matter may be listed after 1 week. We have to file the
You are for the
affidavit.
petitioner?
I am for the respondent number 2,
Okay. Mr.
T. Sunil.
T. Sunil, learned counsel for respondent number 2, has prayed for listing of the case. This time. Wait for listing of the case after 3 weeks. Miss Learned State Council appearing for respondent number 1, 2, and 3 has prayed for and is granted 3 weeks time to file counter affidavit on behalf of the state respondents. Full stop. It is submitted that consent has been taken from the Learned Counsel for the petitioners to make the prayers. Full stop. Place the case after 3 weeks.
Much obliged.
Lordship, item number 8, Lordship.
Item number
8.
8. Yes,
Lordship, this matter may be listed after 1 week, Lordship.
you are for the petitioner.
Lordship.
Yeah, and Mr.
J. Jin, Lordship.
Learned Counsel for the petitioner has made a prayer for adjournment of the case for a week. The prayer is not opposed by Mr. So-and-so Learned State Council or Learned Standing Council.
DSA, Deputy Solicitor. DSA.
Okay. Learned Deputy Solicitor General of India. Also, I'll list the case. The prayer is allowed, list the case after a week.
Diplomat.
On a date 2 weeks by the office.
May Your Lordship, I'm appearing for the petitioners, Your Lordship, for item number 1, 2, 3, and 4, Your Lordship. Your Lordship, the main counsel is out of station due to some personal difficulties.
Out of station?
Yes, Your Lordship. Due to some personal
Yes.
difficulties.
Yes, madam. I do not have any objection, madam. I do not have any objection, madam.
When do you want?
Your Lordship, 25th of this month, Your Lordship.
25th of this month.
Yes.
25th. 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 Okay. Miss
Tokorini.
Learned Counsel appearing for the petitioner has prayed for listing of the case on 25th. 25/4/2025. Mr. Picha, B. Picha. Learned
Standing Council RD.
Standing Council RDW.
RD1, Rural Development.
Okay. Rural Development is in attendance and has submitted that he has no objection to prayer. Release the case accordingly on 25/4. Same 22, 3, and 4.
4.
Same.
And obliged.
Wait, please, Lordship. Lordship, I'm seeking your grace and mercy to challenge one relief order dated 16 April 2024 or 2025. And last week, Wednesday, it was passed by the Government of Arunachal Pradesh, Department of Environment, Forest and Climate Change. Lordship, the petitioner here is a senior IFS cadre, batch of 2006. He is designated as an field director at Namdapha National Park and Tiger Reserve. Lordship, on dated 28 February, a transfer order was issued by Honorable Union of India in lieu of the petitioner. He was transferred from, His Lordship, I may, he was transferred from Arunachal to Daman and Diu. Whereas on March 10th, after deliberation, after the CM has acknowledged the administrative utility of the petitioner, it referred one letter before the Honorable Union of India to reconsider the transfer letter. Now the course of action arises on this relief order dated 16th April, which is annexed on annexure number C, 15, page number 15. Lordship, they have issued one relief order giving the petitioner only 24 hours to vacate the office. Now the petitioner is finding very difficult to submit all the pending works and also to submit the yearly case account. Therefore, the petitioner is seeking some time. And also, Lordship, the urgency of the matter is that the another presiding officer has arrived, he's pressurizing the petitioner to leave the office. Now, secondly, the question arises on the issuance of this order, Lordship. This order, it has to be approved by the state government. An order has to be issued from the secretary at Itanagar only. But however, this order was issued from PCCF office, which is located at Bandardua, Itanagar.
But it mentions that Governor of Arunachal Pradesh is pleased to order relieving.
Yes, Lordship. But it was
Maybe he is an authorized person.
yes.
In a name of governor, he is issuing this order.
But as a central civil servant,
Because governor of Arunachal, the office letterhead says Government of Arunachal Pradesh, Department of Environment, Forest and Climate Change. It is not from the office of the
no, Lordship,
PCCF.
to transfer a civil servant, only the Union of India has to order with the consultant of the
This
state.
transfer order appears to be after a promotion order.
Yes, Lordship. He doesn't have objection on the order which was passed by the Union of India, but
We are not entering into this domain. It's very difficult to enter into this domain.
the course of action is, Lordship,
Cause of action started on 28 February 2025. Just because the Chief Minister has written a letter to reconsider, maybe your service is required to extend the forest cover in Dadra, Nagar, Haveli.
Yes, Lordship. I do agree, Lordship. But they have given only 24 hours to vacate the office. After the
Things were coming, you know that things were coming. Transfer order is on 28 February 2025. You were in the legitimate expectation that something will be coming on any date. So this order has been passed, so I don't think it is with effect from 27 April to enable him to join. So on promotion.
No, Lordship, only praying for like few weeks may be given as an interim.
You make a representation before the authorities. Did you make a representation before the authorities?
No, they have given the relieving order on 16th. On 17th, they have directed to vacate the office. And from there, only like.
Did you make any representation?
We cannot give because there was it was Friday was off, Good Friday, and Saturday the office was closed and Sunday. And yesterday I
So
had
instead of that, you preferred the writ petition.
seeking for justice. Praying for him.
Make a representation. pendency order petition will not be above for the petitioner to consider the submitted representation.
Yes, Lordship, but only like 1 week may be given. Within that they will file.
No, we are not going into the administrative affairs, sir. It is transfer and promotion and transfer. And this was coming since 28th February.
Yes.
The sword was hanging upon you.
No, actually,
Is it not?
yes.
You should have completed your things. You have been granted too much time.
No,
March, April, 1.5 months
they should have given at
to
least,
wind up your affairs, whatever is there.
yeah, pending works. Lord.
Pending works, yes. Just because a letter has been written.
No, we are not relying on the letter which was
You have
forwarded by
got
the
enough
local
time.
CM.
1 month, 16 days time.
Now, Lordship,
To wind up your all the affairs.
Lordship, actually, after relieving order, they should have at least given like 1 week of time to wind up everything in the office.
Where is the provision, sir?
Lordship,
Where is the provision? Where is the
provision
provision,
due
sir?
to short period of time, I could not bring the proper provision, but on the next hearing, surely I'll be.
Promotion and transfer order was on 28th February 2025.
Lordship, I'm
Meaning
only,
thereby, on any date, you'll be relieved.
yes.
Your reliever has already reached perhaps Arunachal Pradesh.
Perhaps they have given only 1 hour, 1 day to vacate the office. That is my.
No, court finds that it is 1 month, 16 days to wind up your affairs. Now, only on 16th, finding that you are not prepared, they have passed this order. Right, Mr.
Asingti.
Asingti.
Yes.
Even
entry-
Yes, what do you say?
Lordship, even the approval has been taken, Lordship.
Approval
Here,
taken?
Lordship, yes, because on IFS officer challenging the release order, not even the transfer order.
You forgot a promotion. You forgot a promotion.
The last page, Lordship. It's rooted to the Lordship, Chief Secretary, Concerned Minister, even Chief Minister, Lordship.
Lordship, I'm only for a few days to wind up all my
The
work.
release order has been issued, Lordship.
To wind up all my work and to submit all the pending works before the.
Maybe granting more time will not be beneficial to the state perhaps.
No, it will cause Lordship,
Perhaps.
I'll prove it. It will cause irreparable loss because
This transfer and postage and so. Yes, yes.
Lordship, the petitioner is transferred to Daman and Diu.
Good place.
And
So
Lordship,
if he travels and if he again
Yeah.
come back to complete the work, Lordship,
and
No, there is no requirement to.
this is the communications from the concerned transferring authority, Lordship.
As such, this is from the state. Let me read it.
On 28 March, Lordship, because he was not released, Lordship. So this is the communication from the transferring authority.
Relief from the state whenever it is.
Release all the Lordship officers, not only the petitioner, Lordship.
For this. Ministry of Forest, Government of India had directed on 28/3/2025
Yes.
for immediate relief of the petition. Failure would result in initiation of disciplinary proceedings. Right, Ministry of Government of India has written to the Arunachal Pradesh state government that release him immediately. Or failure would result in initiation of the disciplinary proceeding. Now, the issue will be if you don't relieve,
That's why I have come before
then
you. Lordship.
disciplinary proceeding will be initiated.
Lordship, that's why I have come before you.
Minister, everybody has acceded. Minister, Chief Minister,
No,
everybody has approved after Government of India's direction.
only Lordship, I am
Well,
seeking for
transfer
a few days. That's why I have come before you.
No, that sword was hanging upon you since 28 February 2025, sir.
But we have to.
If you are not able to wind up your affairs in Arunachal Pradesh in 1 month and 16 days,
But Lordship, we have to vacate the office after the relieving order is passed. And they have given us only 1 day. For that one only I have come.
but your transfer guideline for IFS officers say that transferred officers should be considered stand relieved to join their new place of posting with effect from the date of issuance of this letter.
I do have a reply from
And
that.
Mr.
Lordship, my last prayer may be heard. The petitioner is 59 years of age. Only 1 year is left for his service. And during this time, they are transferring. However, I'm, Lordship, only winding up for the relieving order. A few days may be given.
This is your not your home state also.
Yes, Lordship.
You belong to Uttar Pradesh.
Yes.
Had it been a case of home state prior to your retirement? Yes. But it is first paragraph, Uttar Pradesh.
Yes, Lordship.
And Mr. P. Shungi, learned counsel for the petition. And Mr.
Yes.
S. You are for Union of India?
No, I am for the state.
Okay.
Union
S.
is not made as a
Papin,
party.
S.
It belongs to
Papin.
both.
No, senior government advocate. For the sole respondent post. Para. The petitioner has stated that he is an officer of the Indian Forest Service. Full stop. The petitioner has referred to an order, office order, dated 28/2/2025. Passed by the Ministry of Environment, Forest and Climate Change. Within brackets, oh, not bracket, Government of India. Whereby the petitioner has been transferred from the state of Arunachal Pradesh to Daman, Roman and Diu and Dadra, Roman and Nagar Haveli, Daman, within bracket DMH, Roman and DD, page 2012. Full stop. Para. The petitioner has approached this court being agreed by an order dated 16/4/2025, issued under the hand of the PCCF Roman and H small o FF within bracket EF Roman and CC, page 15. Whereby the petitioner has been relieved from his present post of Conservator of Forest, Roman and Field Director, Namdapha National Park and Tiger Reserve, Miao, MIAO, with effect from 17/4/2025, to enable him to join DNH, Roman and DD of the joint AZNUT cadre on promotion. Post up. Mr. Ichi, Learned Counsel for the petitioner, has submitted that by the order dated 16/4/2025, the petitioner has been granted only 1 day's time to join DNH, Roman and DD pursuant to the order dated 28/2/2025. It is a submission that the relieving order dated 16/4/2025 has granted too less time to wind up two days time to the petitioner to wind up the official business of the petitioner. Also, with such submission, the petitioner, counsel for the petitioner has submitted that the petitioner should be granted a reasonable period of time to wind up the business official affairs in the state of Arunachal Pradesh and in the present place of posting. Post of Mr. Tapin, Learned. No, Mr. Shungi, Learned Counsel for the petitioner, submitted that the impine order dated 16/4/2025 is not passed by the Secretary to the Department of Environment, Forest and Climate Change, Government of Arunachal Pradesh. So instead, the relieving order has been passed by the PCCF Roman and HOFF within bracket EF Roman and CC, page 15, who is not authorized to issue a relieving order release order. It is a release order only. Mr. Tapin, learned senior government advocate, has submitted that though initially a communication was sent from the state of Arunachal Pradesh on 10/3/2025 to the Union Minister for Environment, Forest and Climate Change, Government of India, a communication was received from the Ministry of Environment, Forest and Climate Change. Communication dated 28/3/2025. Whereby the Government of India has requested the Chief Secretary to the Government of Arunachal Pradesh and other authorities to release the IFS officers of Agmut AZMUT cadre 2019, including the petitioner, to join their new place of posting. Was upon receipt of the said communication dated 28/3/2025. The matter was considered at different levels in the government, and it was after approval of the Principal Chief Conservator of Forest, Minister, the Departmental Minister, and the Honorable Chief Minister, the release order dated 16/4/2025 has been issued. He has thus submitted that in view of the above backdrop, the release order calls for no interference. Whereas the materials placed before the court have been perused. It is noticed that by an office order dated 30/12/2024, the petitioner has been promoted to the post of Chief Conservator of Forest, WEF 1/1/2025. After the promotion, the Ministry of Environment, Forest and Climate Change has issued an office order dated 28/02/2025, transferring the petitioner who is in AZMUT cadre, from the state of Arunachal Pradesh to DD, DNH and DD. Full stop. It can be noticed that the petitioner is under an order of transfer since 28 to 2025. Full stop. When the petitioner was working in the state of Arunachal Pradesh, despite the transfer order dated 28 to 2025, the Ministry of Environment, Forest and Climate Change, Government of India, wrote a letter to the Chief Secretary to the Government of Arunachal, Chief Secretary to the Government of Arunachal Pradesh, stating that as per para 8 within bracket Roman small 9 of the guidelines for transfer stroke posting of IFS officers of AZMUT cadre 2019, the transferred officers should be considered stand relieved to join their new place of posting with effect from the date of issuance of the said letter dated 28/3/2025. Post of the letter further mentioned that the officers, IFS officers, next salary were to be given by the segment in which he/C has been transferred. And in case the officers transferred fail to join the segment of his/her transfer, the onus of joining a segment would lie on the officer transferred, and their candidatures for next promotion or central deputation would not be considered as per the guidelines. The officers were accordingly directed by the letter dated so and so 28/3/2025, the Government of India directed that the officers should be directed to join their new place of posting, and their relieving stroke joining report should be sent to the ministry at the earliest. It was further mentioned that failure to join the new place of posting would result in initiation of disciplinary proceeding as per the relevant rules. Also, it is pursuant to the office letter dated 28/3/2025 of the Government of India, the release order dated 16/4/2025 has been issued. Post of the contention advanced by the learned counsel for the petitioner are found privacy not tenable, as the office or release order has been issued under the hand of the PCCF and HOFF from Arunachal Pradesh after approval was accorded by the departmental minister and Honorable Chief Minister, Arunachal Pradesh. Post of. However, before that, I have heard the like counsel for the petitioners also on the interim period. You should notice returnable in 4 weeks. as so and so has appeared, accepted notice. On behalf of the sole respondent, issuance of formal notice in dispense which extra copy by tomorrow. Then the land council for the parties are also heard on the 18th later after this. It is however observed that pendency of the writ petition shall not be a bar for the petitioner to prefer a representation highlighting his grievances, highlighting the difficulties regarding his immediate release before the competent authority.
Not disposing of.
Privacy observation. Otherwise, it will be a case of appeal.
As obliged.
Violation of natural justice. The materials placed by Mr. Tap Supin is kept with the case record by marking it as document X. Yes, sir.
May please, Your Lordship. My Lord, we are challenging a summon order dated 16/4/2025, page number 51, annexure 10.
Page number 51.
Issued by the Deputy Commissioner with the respondent number 3 out here, asking me to appear in respect of a land possession certificate and for recording statements in his office chamber. What has happened, my lord? Before this summon order, my lord, what has happened in this case is, my lord, that there is a land possession certificate was issued in my favor, and there was a dispute. Respondent number 4 appeared before the village authorities. Village authorities, my lord, had issued summon to him. He did not appear for some reasons. Ex parte decision was in my favor, holding that the claims of the respondent number 4 are misleading. In the meantime, my lord, the respondent number 4, my lord, files a representation before the respondent number 3, saying that we are challenging the LPC of the petitioner on such and such ground. Then respondent number 3 gives a memo or gives a clarification information to the respondent number 4 that no, this LPC was issued as per process, as per procedure. Thereafter, my lord, what has happened against the, my lord, village authority decision, which is ex parte, went ex parte against them, he went to the civil judge senior division. And this
What is the jurisdiction of the village authority?
village authority, my lord, Arunachal Pradesh Civil Code Act, my lord. Civil Code Act 2021.
They have any authority?
Yes.
Village authority, what is this called?
My lord, village authority, it is called Kebang decision.
Kebang.
Yes, my lord.
So Kebang has any authority to decide?
Yes, my lord. Civil nature dispute, my lord, land related dispute.
Right. No, whether Kebang is an authority under this, under the Arunachal Pradesh law.
Yes, my lord. That is why they have decided, my lord.
Okay. What is this? What is this called? Kebang.
Yes, my lord. Thereafter, my lord, they approached the, my lord, against the ex parte decision of the Kebang decision before the, my lord, Leonard Civil Judge Senior Division, Pasighat. Again, Pasighat, my lord, senior division passed an order of status quo, against which, my lord, we filed an appeal under 51(2) of the Arunachal Pradesh Civil Code Act, where we got a suspending order. The appellate court, my lord, the Honorable District Judge of Pasighat, my lord, suspended the order passed by the Learned Civil Judge Senior Division. Thereafter, they again came to before this Honorable Court in a civil division.
CRP is supposed to be listed.
CRP is supposed to be listed after view. Today it is listed, in fact, my lord. Today it is listed.
Get the order vacated.
No, my lord. The issue is, my lord, against the order of the district judge, they have filed a.
I have understood.
Yes, my lord.
Now, are you getting this order vacated?
My lord,
CRP.
my lord, we will appear.
Everything has arisen out of it.
No, my lord.
No, it says, see.
Subsequent, my lord, subsequent. After the.
Yes, madam.
Notice will be issued, my lord.
Further proceeding should remain suspended.
Okay.
No point. Once he has issued the LPC, why he is inquiring into it again?
Yes.
Now it is a subject matter of jurisdiction, whatever is there is of the court. First civil judge, then district judge, then CRP, they will decide.
Yes, my lord. And
As regards the LPC, as regards the claim of the respondent for whatever, and the bona fide of the petitioner, then why is entering into the affairs again?
yes,
After issuing an LPC, thereafter declining the claim of the respondent for
yes.
third time he is entering into the LPC again by recording. Why? What for? What purpose he wants the statement recorded? Heard, Mr.
And BP Singha Melody.
and
BP Singha Melody.
okay, and BP Singha, counsel for the petitioner, and Miss Wangmu, T Wangmu, Learned Unit, huh?
K Wangmo.
K Wangmu.
Yes, ma'am. There are two Wangmo.
Oh. Learned Junior Government Advocates. AP. For respondent number 1, 2, and 3. Also, the petitioner was issued a land possession certificate within bracket LPC on 20/05/2022 in respect of a plot of land measuring 25,388.83 square meter situated at Chiku, CHIKU, Riju, RIJO of CG Village, SIJI Village for residential and commercial purpose within bracket subject matter for sort with defined boundaries. Full stop. The respondent number 4 made a complaint as regards the said LPC before the respondent number 3, and the respondent number 3, after inquiring into the matter, decided the matter of LPC granted in favor of decided the matter against the respondent number 4 in respect of the matter of LPC granted in favor of the petitioner. Full stop. The Kebang Authority of CG Village also decided the matter in favor of the petitioner in an ex parte decision dated 22/10/2024. Full stop. Thereafter, the respondent number 4 approached the court of learned civil judge, senior division at Pasighat, East Siam, against the Kebang decision dated 22/10/2024. Full stop. By an order dated 26/11/2024, the civil court had passed an interim order dated. The Learned Civil Court directed the parties to maintain status quo with respect to the subject land. It was further directed that no party shall carry out any further construction, cultivation, or enter into the suit land till the returnable date. The said order was challenged by the petitioner Said order passed in civil appeal within bracket Kebang number 28/2024 was challenged by the petitioner before the district and session judge Pasighat in PSG civil appeal number 03/2025. Post of the appellate court by an interim order dated 11/2/2025. Suspended the order dated 26/11/2024. Post of the said interim order dated 11/2/2025 of the appellate court was challenged by the respondent for in CRP (24 of 2025) before this court. While admitting the civil revision petition, this court on 24/3/2025 suspended the order dated 11/2/2025 of the appellate court till the returnable date. It was thereafter the respondent number 3 passed an order on 1/4/2025 directing the parties to maintain status quo in respect of the subject land and had observed that no party shall carry out any further construction, cultivation, or enter into the subject land until the final order in CRP 2024 of 2025. Post of para. The petitioner has approached this court to assail a summon dated 16/4/2025 issued by the respondent number 3, whereby the petitioner and other petitioner, the respondent number 4 and other persons have been called to appear for hearing. It was held already.
On the on 21st, we did not appear for some reason. And it had not taken place also. What my instruction is.
On 21/4/2025 to record statement in the matter of LPC issued in favor of the petitioner in respect of the subject land. First of the contention of Mr. Sinha has contended that once the matter of grant of LPC in favor of the petition has been decided earlier by the Kebang authority as well as the respondent number 3 on 21/11/2024. Also, the issue is also sub judice before the competent court of law. In such view of the matter, it is not open for the respondent number 3 to reopen the matter of the LPC issued in favor of the petitioner in respect of the subject land. Issue notice returnable in 4 weeks as so-and-so has appeared and accepted notice on behalf of the so-and-so. Issuance of formal notice to the said respondent stands dispensed. The learned counsel for the petitioner shall furnish requisite number of extra copies of the writ petition along with the answer to Ms. Tapin within 3 working days from today the petitioner shall take steps for service of notice upon the respondent number 4 by registered post with AD within 3 working days from today. Post of in view of the projection made on behalf of the petitioner and having gone through the materials on record, this court is of the considered view that the petition has been able to make out the prima facie case. So accordingly, it is provided as an interim measure, it is provided that till the returnable date, the proceeding initiated by the respondent number 3 through the summons dated 16/4/2025 shall remain suspended. I'll come back to the There has been a bomb threat call in principal seat at 12 o'clock. Things are being checked there. Yes.
Your Lordships, here I'm coming against the impugned eviction notice which is issued by the Superintendent of Police. That
Which
is
one?
not in accordance to the
Okay, page.
the impugned notice is at page number 14. And type copy is page 15. here.
Type copy.
May I read? Whereas eviction notice, whereas it has come to the notice of the undersigned that the following persons have encroached on police land at Deomali Police Station complex since a long time and have not vacated till now. The name of the list. Therefore, as per the rule of Arunachal Pradesh Public Premises Eviction of Unauthorized Occupant Act 2003, Section 4, the aforesaid mentioned above persons are hereby issued eviction notice to vacate the police land within 30 days of receipt of this notice, and vacation report may be
Yes,
submitted.
madam. Section 4, it should be a notice.
It should be a SOCUS notice.
So thereafter, section 5, then thereafter section 6.
Section 6. Even there is a judgment of this honorable court wherein it says that the superintendent of police have no authority under public premises.
Your Lordship, in this matter, Your Lordship, so far I know the Superintendent of Police are also being designated as a state officer.
Okay.
They can carry out the eviction.
Okay, let us assume for a moment. Superintendent of Police is the asset officer.
Yes.
And within a notified area of police department, Your
Okay.
Lordship.
Okay, done. Assume. Then it should be noticed under section 4. Then he should be given an opportunity to establish his claim that yes, he is not an unauthorized occupant. Thereafter, an order is to be passed under section 6 to vacate the land. So, under section 4, he cannot say that.
Vacate the land.
And then, Your Lordship, I need to
Vacate
take
the land.
instruction, Your Lordship.
To take instruction,
Yeah,
we are
notice,
assuming that.
Notice may not be issued, Your Lordship. Today, Your Lordship, I will take instruction, Your Lordship.
Okay. Day after tomorrow.
Okay, okay,
Till
Your
then, no
Lordship.
course of action.
Till then, stay.
No course of action in terms of this eviction.
Can it be on 5th of May?
No, we'll decide if they can, because this
Okay, Your
cannot be
Lordship.
done. Under section 4, eviction order cannot be passed.
Yes, that can.
It can only be passed under section 6.
6.
After following the procedure laid down in the act. I think this Arunachal Pradesh
Public Premises
Act, do you have the act?
Yes, I have that.
It is no different from the other. acts.
Yes, yes.
I think same.
Yes.
Get the judgment of Nusli Wadia,
Okay, I will get that.
NUSLI Wadia. The Bombay Dyeing man. Owner of Bombay Dyeing.
Yes, Lord.
You know Bombay Dyeing? The
Yes,
cloth.
yes, Bombay.
Even it is assumed, madam, the superintendent of police is an asset officer, then he has to be given the notice to show cause,
What is
not to vacate. Then
this
this calls for crossing.
in this regard, Your Lordship, I will take instruction.
Even after crossing, you will be at liberty
Yes, he has.
to proceed in accordance with law. So take the instruction.
Okay, Your Lordship.
Day after tomorrow?
Okay, Your Lordship.
Can it be on tomorrow?
No, it will be
Not
two.
tomorrow, Your
But for me, because I'm an outstation advocate, if I go tomorrow, then again I will have to stay for 2 more days.
Tomorrow won't be possible, Your Lordship. It's from concert, yes.
Then it will be next week then.
Okay,
Then can it be on 5th of May?
Yes, yes, madam.
okay, Your Lordship.
Heard Mr.
Deboke Deori.
D.K. Devi.
DK Deori.
D.K. Devi. When it comes about a petitioner. And Miss
P. Pangu, Your Lordship.
P.
P. Pangu.
T. Vamu. Junior government advocate. AP. For the respondent number
1, 2, and 3.
1, 2, and 3.
Yes, sir.
Okay, petitioners.
It's a common constraint.
Your names are where?
24th.
CL number?
I'm at serial number 1.
Then
And 4.
3 and 4. Okay. An eviction notice issued by the respondent number 2. Eviction notice dated 21/3/2025. Issued by the respondent number 2. Purportedly under section 4 of the Arunachal Pradesh public premises within bracket eviction of unauthorized occupants within bracket Act, 2003 has been put to challenge in this writ petition. First of, by the eviction notice, the respondent number 2 has directed the 7 number of persons, including the 3 petitioners hearing, to vacate the plots of land within a period of 30 days from the date of the said notice.
Or date of receipt.
A receipt of the said notice. Post of. It is mentioned there in the notice that the plots of land the petitioners are in occupation are police land. Post of. The primary ground of challenge is that under section 4 of the Arunachal Pradesh Public Premises Eviction of Unauthorized Occupants Act 2003, an asset officer can issue a notice following up on the person concerned to show cause as to why an order of eviction should not be passed. And thereafter, the person on whom the notice under section 4 has been served should be given an opportunity to show cause and to produce any evidence in his support. And it is only after a person hearing, a notice to vacate the alleged public premises can be issued under section 6 of by the asset officer. Ms. So-and-so, junior government advocate, has sought some time to obtain instructions in a matter. I'm sorry, Mr. Deori, the concept of petition has further submitted that the respondent number 2 is not an asset officer under the Act. Purpose of behavior next. Ms. So-and-so, before obtaining instruction, recover, Ms. Tapin. sorry, Wangmu, right? Wangmu.
Yes, yes, Your Lordship.
And a uniform advocate has submitted that the Superintendent of Police has been designated as an estate officer under the Act of 2003. Pusto CS Pardas submitted that she would obtain necessary instructions in the matter and has paid for some time till 5th of May. 5/5/2025. Pusto. As sought for by Mr. Pin, Wangmu is the case of so and so. Having regard to the projections made and on perusal of the notice, eviction notice dated 21/3/2025, it is observed that there shall not be any coercive action against the petitioners in terms of the said eviction notice dated 21/3/2025 till 5/5/2025.
God bless.
I furnish one extra copy.
I will find.
Mr. Deori, counsel for the petition, shall furnish a copy of the writ petition along with an answer to Ms. Wang during the course of the day to enable Ms. Wangmu to obtain the necessary instructions.
God bless.
Yes, Your Lordship.
Please, my lord.
Yes.
My lord, these three writ petitions, my lord, arising out of the same course of action. These three writ petitions, my lord, it arises out of the same course of action.
Same cause of action.
Action.
Okay.
This is also with regards to vacation, eviction of the petitioners in the highway stretch. Firstly, my lord, the facts, my lord, that we have been, these three petitioners, they have already been compensated for the damage caused to their property, man. For the construction of the highway, my lord.
Let us see which is the highway first.
Annexure 1, my lord. At page 18, my lord.
Page 18.
18, my lord. And typed copy is at page 20.
Copy page 20.
So this land was acquired in percent of so and so, so and so, so, under the section 10 of the Zoom land, my lord. Whereas the power to acquire land is vested the government of Arunachal Pradesh, and it is the competence of government to notify any land within the state of Arunachal Pradesh for purpose under section 10 of the so and so act. And whereas the government of Arunachal Pradesh is satisfied that the land mentioned in the schedule below is needed for public purpose, namely for construction of existing road to two-lane national highway standards, along with improvement and realignment starting with Tai to Gabu stream. The land of the petitioners will fall under this stretch. Gabu stream, part of Arunachal Pradesh package of packages for roads and highway on National Highway 229 here in after National Highway 229 falling under the jurisdiction of Deputy Commissioner, Western District alone. So, my lord, that's...
So this is the initial notice.
Yes, my lord. The land was acquired, my lord, and annexure 2, if your lordship may come, page 22. At serial number, this is the notification regarding the national highways, my lord.
This is an NH 229.
Yeah. Now,
Where
of
is
course,
that,
that
in the
name,
Government of India, which part is this?
Government of India, my lord. That
Notification?
stretch has been, is now national highway, my lord.
Which one?
At serial number 38 at page 26, my lord.
Page 26.
26, my lord.
Tawang.
No, my lord. Page, yes, serial number 38, the page 26, my lord. Their highway starting from Tawang, connecting Bomdila, Nichipu, Sepa, Sagali, 0, Daprojo, Along, Pasikat, Teju, and terminating its junction with National Highway 15 near Wakro in the state of Arunachal Pradesh.
This is highway number 13.
Yes, my lord.
Same thing, 229.
Yes, my lord. Now these numbers have been changed, my lord. Otherwise, this notification, my lord, is from 2014 that,
This notification 2010. Subsequently, this notification is
Well,
2014.
yes,
Okay.
these numbers have been changed. Otherwise, it's not disputed, my lord. The state is also not disputing that it is not a national highway. Now, my lord, that compensation has been paid, my lord, and our structures, my lord, that was falling under the right of way, my lord. We were compensated, of course, suitably compensated. We accepted the compensation. We damaged the portion that was falling under the highway, my lord. And remaining portion, somehow we managed to save and we are leaving there, my lord. It is said, if your lordship can come to annexure 4 is the
Annexure?
for photographs, my lord.
Which part? Right part or left part?
This is the right part.
Right part.
Yes, my lord. We somehow managed to protect this, and
Who has constructed this retaining wall?
this, my lord, is by the executing agency, man. Now the roads have been completed, man. Everything done, my lord. This highways complete. This is the picture of the drain, highway, everything, my lord. Everything done. Now the estate officer, my lord, has given a direction to vacate this and demolish our
Which one?
property. Is it at annexure 5, man? December 2022, man. Order. This is by the EAC. Whereas it has been brought to the notice of undersigned that some persons who are suitably compensated against their property in the National Highway 13 right of way under Tirwin Circle has not vacated or removed their building structure in spite of repeated requests and direction from the concerned officer engineers for smooth and early execution of highway road construction work. Such type of hindrances and non-cooperative attitude of some unmindful person creates big obstruction in the smooth process and timely completion of targeted project. And whereas on the basis of report furnished by the Executive Engineer PWD Highway Division, Basar, pertaining to the detailed list of standing structure within National Highway 13 row under Tirwin, which has been suitably compensated by the government are as under. Now the petitioner is serial number 9. His name is at serial number 17, ma'am. Tanga Gamlen, ma'am. Stage number so and so, date has been mentioned, ma'am. And down.
What is SPT? SPT means?
Semi-permanent type, ma'am.
Semi-permanent?
Type.
Type.
Yes. But otherwise, we also call it Assam type also, ma'am. That not RCC, ma'am.
Location.
Down below, ma'am. Therefore, considering the above facts and keeping in view of the urgent need of time-bound national highway project under Tirwin Circle, and also in the interest of public service, I do hereby order the above illegal occupants to vacate the building and remove the standing structures from the said location by themselves within 10 days from the date of issue of this order, so and so. That is on or before 7/1/2023. Now the EAC come estate officer, my lord, under the Arunachal Pradesh Public Premises, my lord, that Eviction Act, my lord, he has issued this order, saying that the portion of my house, my lord, that I somehow managed to protect, it should be demolished so that the highway can be completed. Whereas otherwise the entire project is completed. And otherwise, our basic stand is that, my lord knows that under the National Highways Act, highways, the land under the highways west with the central government, Union of India, and under the highways that Traffic and Control Act, my lord, under that there is a National Highway Administration, my lord, who is the authorized person, my lord, who has the jurisdiction to remove any illegal unauthorized occupant from the highway, not the estate officer. That is basically our case.
Whether National Highway authorities are party?
Yes, Malay. Union of India is a party, Malay. Union of India is a party. The constructing.
What is the stand of the state respondents?
State
in the
respondent,
affidavit?
State respondent, they have filed affidavit. They have said that the estate officer has
Let
the.
us see their stand. Who has filed the affidavit?
Your Lordship, 4 and 5, Your Lordship. 4 and 5, Your Lordship.
4 and 5.
Yes, Your Lordship.
4 and 5. Who are 4 and 5?
Deputy Commissioner and Deputy Commissioner and the EAC. Yeah, my lord, even the constructing agency.
Deputy Commissioner and Extra Assistant Commissioner,
Yes.
Estate Officer.
Estate officer.
Okay. What about the petitioner's contention that National Highway Act will come?
Your Lordship,
It is the National Highway Administration who should, who are authorized to do so.
Your Lordship, in our page number, Your Lordship, 61, Your Lordship. Annexure
Page number
61. Annexure 13, Your Lordship.
61.
The type copy is at page 62, Your Lordship.
Okay.
Yes, basing on this only, we have passed the vacation order, Your Lordship, eviction order. This is, my lord, that
No,
state act.
no state it also. Now, this National Highway Authority, they have entered appearance.
It's the Union of India, my lord, they were made a party, my lord.
Ah.
Copies were also served, my lord, that
Is there any?
earlier they DSGI was appearing, my lord, but DSGI, my lord, he entered appearance also, my lord. But they have not filed any affidavit, my lord.
Oh, is,
But I
is he present?
if your lordship
No,
can,
firstly, it is whether it is a public premise, whether it is a public premise.
in my humble understanding also, after the acquisition is complete, it will the road constructions of roads, it will all belongs to the public
Question is
purpose.
whether it is a public premise.
Yes, your lordship.
This national highway, it is a centralized,
My lord, my lord.
is it not?
Yes, my lord.
After, who pays the compensation? Sir, who pays the compensation? The money.
National Highway, lordship.
Highway.
Yes, sir.
Then it becomes the land vested in the central government as per the National Highway Act,
Yes. Yes, your lordship.
right?
Yes, your lordship.
Then in that case, whether it comes within the definition of public premises under the Arunachal Pradesh Act. Huh? Oh, these are the issues.
Yes, your lordship.
Whether, what is the definition of public premises? Any land or structure belonging to the state government
Yes, your lordship.
or any other corporation or public sector undertaking owned and sponsored and controlled by the state government. Public premises means any land
Yes, your lordship.
or structure belonging to the state government
Yes, your lordship.
and any other corporation or public sector undertakings owned and sponsored and controlled by the state government. So, and premises means any land or building. So, public premises, if the land belongs to the state government,
Yes, your lordship.
ROW. If it belongs to the state government, then this officer will be an estate officer.
Yes, your lordship. Yes, your lordship.
And if it is not a land belonging to the state of Arunachal Pradesh, then he cannot be an estate officer.
That is also true, your lordship.
So this issue has been raised perhaps by the petition.
Yes, my lord. Yes,
And he is saying that it should be under another act.
yes, my lord. I have provided a copy of the National Highways Act, my lord.
Because National Highway Act, if you
Section-
see,
Section 4, my lord.
if you see section 3, section 3,
Or else my lord is referring
section
to
3,
section 4, my lord. That,
one minute. Section 3D2. On publication of the declaration so and so, the land shall vest absolutely in the central government. Right. Then section 4. National highways to vest in the union. Yes, at the time of acquisition, power can be given to the state government authorities to acquire the land.
Yes, your
And money will be deposited by the central government to the state government. You pay the money
Yes,
to the beneficiaries or the landowners, person interested. Right?
yes, sir.
After the land has been vested, suppose it is a national highway,
Yes, your
then the question is to be answered by you that the land and ROW
Yes.
is still vested in you, or else the power has been given or delegated by the central government to the asset officer. It can be delegated perhaps.
Yes, of course, of course.
Yes, but we have only these documents to show up.
No, this has been declared as an asset officer.
Yes, your lordship.
But for what? Page
61, your lordship.
61. Under the Ownership Protest Act.
Yes, your lordship.
And under the Ownership Protest Act, public premises means land belonging to ownership protest.
Yes, your lordship.
But if it is a national highway, the land vests in the central government,
Yes, your lordship.
then how can he exercise the power on the basis of this page 62 notification? Because it has some importance. Because it is a case of, say, infrastructure.
Yes, your lordship.
If you can answer the issue, then it will go against the petition. If you are saying that you have paid all the money, even for the structure to be demolished,
Yes, your lordship.
where from you are saying?
Your lordship,
That the photograph he has shown, one part of a building is there. And you have constructed the retaining wall.
it was on the complaint of the company as well as the PWD highway. We have initiated.
There should be some basis.
Yes, your lordship.
I have seen from the photograph, there is a retaining wall.
Yes, your lordship.
I have put the question to him, who has constructed the retaining wall?
Yes.
He is saying that
I'm for the respondent 7.
7, yes, tell me,
I'm the contractor now.
yes.
Now the road has been completed, madam. We have built the drainage and the bridge wall as well, madam. Our road is completed. The road is in good condition. It's working on the roads are, the vehicles are flying.
The vehicles are flying.
As far as I'm concerned, madam, we are only confined.
You are a contractor,
Madam.
whatever land has been given to you, you have constructed the land,
Madam.
the road. The question of paying money, money has been paid. Not by you, by the government.
Madam.
Yes.
But sorry to interrupt, my lord, but the order, if your lordship will see, it says that the remaining portion that I have somehow, my lord, I have managed to save, my lord, the portion of the building. It
You have
is
saved, so.
obstructing in the construction of the highway, my lord. That is
Why
why it
is
is.
the Deputy Solicitor General of India?
But otherwise the highway is already been
If he
completed.
says that national highway is complete, end of the matter.
Completed otherwise. Yes.
Let him say so.
Oh,
Let
of
it-
course.
Can you call?
But at two, my lord, I will ask.
Because if he says that the highway is complete, respondent number 7 is constructed, we have no issue. Then there will be no bone of contention then.
No.
It will stay like as it is today. If he says that yes, we have paid the money, but we have not still got the land which have been acquired. But under this notification, you may not have the power to issue such notice.
Yes, Your Lordship.
Where is the other act? Where is the other act, Mr.
That I have provided also.
Control of National Highway Land and
Yes,
Traffic?
traffic.
Which provision? Section 23 perhaps.
Firstly, my lord, there is a provision for at section 3 establishment of the highway administration, my lord.
Page section?
3, my lord. Highway administrator has to be appointed, ma'am. And there is section 20.
Actors of a body or of a consuming one or more officials of central or state government domain. Yes, if under section 3(1)(a), if that authority is,
Yes, my lord, that is, my lord. If it is there, my lord, it is there.
have
And-
you addressed, sir, in your affidavit?
My lordship.
Do you have the, please provide him.
Yes. No, Your Lordship. Their stand is that since their basic stand is under the AP or our state public eviction act.
Section 3. One, the central government shall by notification in official gazette, small a, establish for the purpose of this act a body or authority consisting of one or more officers of the central government, you leave aside central government, or the state government, to be known as highway administration, to exercise the powers and discharge the functions conferred on it under this act. Right?
Yes, Your Lordship.
So central government by notification can confer the powers on the officers of a state government
Yes, Your Lordship.
to act as highway administration.
Yes, Your Lordship.
Right?
Yes, Your Lordship.
Then you come to section 23 onwards. Section 23,
Removal,
highway land to be deemed as property of central government. Okay.
Yes, Your Lordship.
26, my
Then
lord.
26,
Yes.
removal of unauthorized occupation.
Yes, Your Lordship.
Right, where the highway administration or the officer authorized by such administration in this behalf is of the opinion, it is necessary in the interest of traffic safety, so and so, so and so, so and so. So, that authority can issue.
Yes, Your Lordship.
That is the answer we need. Yes,
My-
your response is not available here.
I'm sorry, my lord, I was attending my officer.
Your response is required perhaps
My lord, I'll take instruction.
because here the state government officials are issuing a eviction notice for national highway land.
My lord.
If the state government officer is given the authority, they can do so.
Well.
But here they are exercising the power under the Arunachal Pradesh Public Premises Act.
My lord, what I'm, my lord, aware is that by, my lord, the state government notifications, my lord, some of the officer has been authorized, my lord.
But public premises under the Arunachal Pradesh Act is for land belonging to the Arunachal Pradesh,
State government. Correct.
not for the central government.
Well.
Otherwise, a civil, say, circle officer or the district commissioner cannot go to the railway property and issue
Correct.
eviction notice in respect of railway land.
My lord, I'll take it.
Inside the state, there are lands belonging to railway, defense, say for national highway.
Correct.
State government officials cannot go there and issue eviction notice as estate officer.
My lord.
Unless he is given power by the central government.
Correct.
Here, state government's contention is that we are accessing power under the Arunachal Pradesh Unauthorized Act. And that act is applicable only in case of lands belonging to the Arunachal Pradesh government. And he is saying national highway land belongs to the central government.
Correct, my lord. But my lord, as per my lord, my lord,
Only a notification is necessary from your side.
correct, my lord. I'll take instruction.
Or from his side, that this officer has been given the power to act as an authority under the National Highway Act to clear evictions. End of the matter.
Provision may be, my lord, wrong, but some of the officer has been designated as officers of it. My lord.
That assistance is required from the council only,
Yes, ma'am. I'll come with the instruction.
both from your side. Your page 62 is of no use. Prime officer. Respondent number 7 has no role here. You take instructions in a matter. This way, otherwise, if you have paid the money and these petitioners are occupying your land,
Right.
that is one case. Or the other is that they are having their own land.
Well,
And everything is in public interest. Suppose, wait, order is to pass. Heard, Mr. Lawson,
D. Soki.
D.
Soki.
Soki, Learned Counsel for the petitioners. Mr.
Y. Ram, Your Lordship.
Learned State Counsel for the respondent number
134 125, Your Lordship.
125.
Yes, sir.
One, 2, 5. PWD,
No, Your Lordship.
Mr.
I have four respondents, 7, 4, my lord.
Learned Counsel for the respondent of 7, and Mr. Sunil, Learned Deputy Solicitor General of India for the respondent number 8, 9, and 10. 8, 9, and 10.
only in 8, 9, my lord. They have their own extended council. National.
Okay. Who has entered appearance?
As per the case, case wise, they are allocating.
In this case, Mr. Counsel, please help us. On whom you have served a notice? Who has entered appearance?
My lord, I think
Can directly serve to the matter since office is located in Itanagar.
No, I think notice has been issued perhaps.
I have
This. By which order?
I'm sorry about that, madam, because because
Huh?
this was earlier conducted by Mr. N. Ratan, madam. So before earlier orders, I'm slightly unaware. I'm extremely sorry about that.
You should have got yourself apprised.
Because I was under the impression that
You were enjoying interim order.
Learned DSGI is appearing for all the respondents, madam. Newly
Which?
fresh impleted respondents, madam. That
By which order? Union of India required to emit.
25/1/2023, madam. The initial order
issued,
it-
making the same returnable. Then.
Because otherwise we had served the copy to.
Find out, sir, find out. At 2, I'll pass the order.
Well,
Find out on whom it is served.
we,
Otherwise, the process will be delayed again.
that copies we have served to the DSGI, my lord.
For all, 8,
For
9,
all,
and
my
10.
lord. Yes, my lord. 3 copies, my lord, we had served.
Serving 3 copies
That
is
is
okay,
why-
my lord.
that is
I
why
cannot-
we-
I cannot appear on behalf.
That is why we are under the impression that he was appearing, my lord.
Who is this standing council, NHAI?
That time,
Please call him.
Well, the NSCL, they are fellows of advocates. They engage as per case.
He will communicate the copy to the office. Thereafter, whoever will be engaged, he will appear. But call any of the panel council.
In some of the cases.
Or otherwise, you have to serve notice.
Yes, that can be directly served.
That we can do, Mother. But on 27 January, after this first order itself, we had served the copies to the DSGI, Mother. So that is why we are under the impression, my lord. That he is representing all the. Today only we came to know. We are knowing that for NHI DSL they have.
Okay, we'll sit at 2:10. I will pass the order there. In meantime, you check the
My lord.
office notes. You are Mr. Soki, right?
Man, I've checked the records, my lord. We were all along under the impression, my lord. And orders has also been for only for the respondent number 7, my lord.
Respondent number 7 is only a contractor.
Contractor, man.
It is the National Highway and the central government who has to decide on the right of way.
Man.
If they say that right of way is okay, then end of the matter. Heard Mr. D. Soki, Learned Counsel for the petitioners, and Mr.
Y. Ram, Your Lordship.
Y.
Yes.
You are State Council?
Yes, Your Lordship.
Learned State Council. For the respondent number 1 to
5. Your Lordship.
5. And Mr. So, Mr. Opara, Learned Counsel for the respondent 7th. And Mr. So, Learned Deputy Solicitor General of India for the respondent number 8 and 9. Full stop. Mr. So, the Deputy Solicitor General of India has submitted that though he has earlier received the notice on behalf of the respondent number 10, National Highway Authority of India, NHAI, there is a set of panel council for the NHAI. And as such, he will not be in a position to obtain instructions from the respondent number 10. First off, he has further submitted that he will obtain instruction as regards the right of way of National Highway number
13, my lord.
13. And in a matter pertaining to the control of national highways within the Land and Traffic Act 2002 from the respondent number 8 and 9. So we have short listing of the case after 2 weeks. Okay. As for proper adjudication of the issue, the presence of respondent number 10 is necessary, any council is there? The Learned Counsel for the petitioners shall take steps.
In some cases, my lord, for NSCL,
You can appear.
some cases, but then that has to
Okay.
be endorsed.
Okay. Learned Counsel for the petitioners shall serve a copy of the petition along with annexer to Mr. So-and-so, who in turn shall transmit the information to the respondent number 10.
My lord.
So that the respondent number 10 is represented by its learned and engaged counsel in the matter. Within by tomorrow.
No.
By tomorrow, huh? By tomorrow. Learned State Council, Mr. Lufesu, Learned State Councils have also obtained instruction as regards the authority to issue an eviction notice by the Respondent number 5.
Yes, Your Lordship.
Who is admittedly an authority under page 50,
61, Your Lordship.
61.
5 copies at 62.
61. Who is an estate officer under the public premises within bracket eviction of unauthorized occupants bracket close Act 2003 Arunachal Pradesh, public premises, comma, as an authority stroke asset officer in respect of a right of way of a national highway which is admittedly vested in the central government, which is primarily vested in the central government. It is the case on given agreed raise the cases after 3 weeks.
After
2
3
weeks on a day to expect.
Obligations.
This. Yes.
My lord, item number 12 and 13 has become infructuous, in fact. My lord may allow me to withdraw.
Okay. Both the cases.
Both the cases, my
Yes.
lord.
Okay.
Tender matter, my lord, no interim was granted in the meantime.
Mr. D. Pangi.
My lord.
Learned counsel for the petition. For the petition. Has submitted that the subject matters of both the writ petitions have become infructuous. First of, who are the state councils for the respondents?
I am for 1 to 5. Standing concern of the building. 1 to 6.
1 to 6.
Yes.
Okay, Mr.
G. Tarak.
Learned Standing Council. Rural Works Department. AP. And private respondent?
Lordship, I am for respondent number 7 in the first item number 12 and for private respondent number.
Item number 12 of Mr.
A. Tata.
A. Tata, Learned Counsel for respondent number 7 in 12.
Yes, Lord.
In 13?
Item respondent number 8.
Respondent number 8 in 13. Anybody representing 8?
No,
Other
madam.
respondent?
No, madam.
Are present in view of the votes. Submission made by Mr. Pangi, Learned Counsel for the petitioner, both the petition being infructuous, stand dismissed. Oh.
Item number 16.
If somebody made a mention, somebody made. Yes, madam, you made a mention.
Your Lordship, on last occasion, we have prayed for the amendment of the petition.
Amendment?
Yes, so the petition is already completed, but we couldn't swear in the petition because petitioner couldn't come, so we may be given some more time.
To amend the petition by informing the government is subsequent notification issued by the response.
My lord. I'm appearing for Power Grid here, my lord. My lord, I'm appearing for Power Grid Corporation of India Limited
Yes.
on a number 2, 3, and 4. My lord, in this matter, we had filed an affidavit raising the grounds of maintainability in this particular writ petition that they have filed, my lord. And the primary ground is that there is a specific alternate remedy which exists under the Indian Telegraph Act, my lord. Now, my lord, on the previous occasion, while order dated 18/3/2025, my lord, the order does not speak about amending the writ petition. It says that they would be producing some notifications, my lord, government notifications. Now, my lord, production of government notifications and the legislation, that is the law as it exists, that can be produced in any form and at any stage during the hearing. My lord, order dated 18/3/2025.
Praise for allowing him to amend the writ petition.
My lord.
By incorporating the government notification and the subsequent notification issued by the government.
My lord,
I don't know. I have to also go by the order also.
My lord.
Right.
My lord.
I know it might be a case of under section 10.
My lord, section 16, my lord.
Section 16 read with section 10 perhaps.
My lord. My lord.
Indian Telegraph Act, Indian Telegraph Act read with Electricity Act.
My lord, 164 of the Electricity.
And you are in transmission and utility, there is no question of acquisition of land.
My lord.
It is only right of user.
My lord.
And there are notifications of Ministry of Power.
My lord.
2015.
My lord, 15 is the guideline adopted by Arunachal 19. That is
2015 perhaps there is a central government notification.
There were the recommendations, my lord. And
whatever guidelines, there are guidelines.
My lord. So,
now what to do? The previous order is there.
If my lord, if I can have an audience of only a minute, my lord, here. My lord, whatever notifications they bring, their prayer, my lord, their prayer in the writ, page 24. My lord, they have a threefold prayer over there, my lord. Firstly, they are saying for giving them compensation under the LARA 2013, my lord. Now, section 105, schedule 4, entry 12 by itself prohibits the application of the 2013 Act, my lord, to us, as the Electricity Act 2003 is exempted. Second, my lord, they are asking for certain, they are stating
Mr.
certain.
Counsel, I know, but because of the order,
my lord,
I have decided n number of cases on it.
My lord.
Right?
My lord.
Principal Court of Civil Jurisdiction.
My lord.
What to do? Yes, madam, the counsel for the petitioner perhaps is not available.
Yes, the main counsel is not available.
The leading counsel is not available, sir.
My lord, the issue of maintainability may be kept open and this matter may be listed on the 5th of May.
Okay.
In the admission list, sir, my lord.
Maintainability is kept open.
Yes, that is always there.
Okay. Miss
S. Somu.
S.
S. Somu.
Heard Miss S. Somu, Learned Counsel, appearing on behalf of Mr.
S. Mo.
S.
Mo.
Mo. Mo. M-O-W. Learned Counsel for the petitioner. Mr.
N. Khera, my lord.
N. Khera.
N. Khera, my lord. For 2, 3.
Learned Counsel for the response number 1.
My lord, 2, 2, 3.
2, 3.
My lord. And 5.
Okay.
2, 3, and 5, my lord.
5. Mr. Deputy Solicitor General of India for the response number 1. And Miss Wangmu.
Yes.
Yeah, Wangmu.
4
And
and
counsel for the response number
4 and 6.
4 and 6. Full stop. Miss so-and-so Learned Counsel, appearing for a petition, has paid for how much time? Okay.
2 weeks, Your Lordship.
2 weeks means is seeking 5th of May.
My lord.
2 weeks.
Learned friend here had seeked a week's time in the morning, my lord. We had said that let it come up. So 5th of May, my lord, it's a notification they have to produce. We
As
can-
sought for a week's time.
Yes.
Full stop. Mr. Khera, Learned Counsel waiting for the respondent number 2 and 3, has reiterated his plea of maintainability of the petition. The prayers stroke direction sought in this petition. Full stop. As sought for by the Learned Counsel for the petition and as agreed to by the Learned Counsel for the other side, this is the case on 5/5/2025. Full stop. The issue of maintainability raised by the Learned Counsel for the respondent number 2 and 3 is kept open for consideration on the next date of this.
Much
Highly obliged, my lord.
My lord, this is today's for admission hearing for the miss case.
Miss case.
Yes, my lord.
Okay.
Yeah. Now, my lord,
What is the main case?
the main case is, my lord, actually main case is under that Gram Panchayat member during the election times in the year 2024, under this is Arunachal Pradesh Provision of Authority Defection Act, disqualification of some members of the political party from the BJP party. They have disqualified during NT party, in the list of NT party. So that I am belong to a political party of the BJP party. During the election times, our elected Gram Panchayat members.
Let us see the main case, then only you can understand the
Yes, yes.
IA, right?
Yes, yes, my lord. The main case is, my lord, like this.
The petitioners, how many?
11 petitioner, my lord.
11. Yes.
11.
What happened? What is impugned in the main petition?
My lord, imprimatur order imprimatur order is that
Take us
the
to
petitioner is the mislead the dishonorable court.
Hmm?
No, petitioner is the mislead the dishonorable court.
Petitioners
Mislead the dishonorable court for obtaining of this interim orders, my lord.
Who are the applicant in the IA?
Yeah, IAS, my lord, my lord, please see the annexures.
No.
In IA.
No, who are the applicants in the IA?
The IA is the model president of that 12 Assembly Constituency Kesang, my lord. Model president of the
He is one
Bharat
of the
Janata. Yes, my lord.
They are respondents.
Yeah,
They are
respondent.
respondents.
Respond number 5.
Respond number
5.
President Pake Kesang District BJP Unit.
Unit.
He is the applicant here in the IA.
IA, my lord.
Okay. Let us see the interim order.
Annexure,
Date.
page, my lord, page 15, annexure 1.
Date of the interim order.
Yeah, my lord, this is date of interim order.
What is the date of the interim order?
Date of interim order 16/8/2024.
Okay, let me read it.
Yes, sir.
Where is the impugn order in the writ petition?
At page 55, Lordship.
Hmm?
55, page 55. It's serious, Lordship. It starts from page 55.
What is this act?
This is my lord, the Arunachal Pradesh AP code volume 8. Arunachal Pradesh Local Authorities Provision of Depiction Act 2003, my lord. Page 175. Bolu.
175.
Yes, my lord.
Yes.
Yes, yes, my lord, there, under section 3 of the clause 1, my lord, this act is clearly stated that the subject to the provision of the section 4 and 5 and 6, member belong to the any political party shall be disqualified for the being such members. Number 1, if he is voluntarily give up his membership, such a political party. My lord, in this case, the petitioners has been give up their membership. They have resigned from their post. My lord, please, my miss case.
Miss case.
Miss case. My lord, please see my lord, they are resigned from their post. Yet annexures 2 series page 33 of the miss case, my lord. My lord, this is to the president's Pake Kesang District Unit, Bharatiya Janata Party, Arunachal Pradesh, subject resignations. With a heavy heart and strong dissatisfactions, I am tenders my resignations from the primary and active membership of the BJP due to failure of the successful implementation of the policy Sabka Saath Sabke Vikas under the leadership of the Shri Bhiram Wage, State President. Therefore, I morally tender my resignations from the parties, from the BJP parties, and support the NCP under the leadership of DC Himu for the greater interest of the area man. This is yours respectfully, Bado Navam GPC, Gram Chairperson, my lord. This is another's. The another is, my lord, page 35. The page 35. Page 35. This is also resignations, same matters, and yours respectfully, Shah Navam, Gram Chairpersons, and Hote Panchayat Pakikations. Another is, my lord, that my lord, out of that 11 petitioners, the 6 are give their resignations. The rest are not give, my lord.
Okay, 6.
Yeah, 6 are give their resignation from the membership. Accordingly, that learned deputy commissioners has been disqualified. His order also mentioned clearly they are resigned from the post.
Wait,
But
order, mention it.
yeah, my lord, order.
Let us see.
Improve order, my lord, the page 35 of the petitioners.
Page
Well, this is the original also, is the original of the order passed by.
It is there.
It is there, my lord.
Tell me
Yeah,
where it is reflected that they have resigned.
yes, well.
It is
Page-
there, I think.
Page,
There is no dispute.
my lord. no,
Keep the original.
no dispute. No dispute.
Where it is
Yeah, yes,
mentioned that they have resigned.
My lord, here the separate or the page number, my lord, page number 59,
59.
59 and 59, 50, 60, the last paragraph, my lord, page 60, order 60 of second paragraph in here, my lord, here that had the both the party 60, they pursue the record, and therefore I am the opinion that respondents breach the aforementioned party whips and among to the anti-party activities. Respondents has also voluntarily resigned from the primary membership of the party by his own violations. My lord, this is clearly already resigned. Order is mentioned. So that by similarly order may next also, my lord, here. Next is, my lord, the
Is
page 62, my lord.
62.
62.
There is no resignation.
Here is further activities of the anti-parties. Is it the no resignation? Another is
No
page-
resignation.
No resignation. Another page 53, 54.
64 is no resignation.
No resignation. And
Mhm.
65, my lord. 65, 66, my lord. Active
No.
party, his is adding explosive order of the anti-party by the further sections. Page 68.
68.
Yes, my lord.
68. No.
Okay. Or 70.
70.
71 is.
71, 72. 72 is there.
72 is there, my lord.
74 also there.
73 and 72.
74. 76.
6 also there, my lord. Yes, my lord.
So how many? Out of 1, 2, 3, 3. Total 4 or what?
Just make my
Total out of 11 petitioners, how many have voluntarily?
just minute, sir. Just 1, 2, 3, 4, 5. My lord, 5. As per the report, as a resignation.
5.
5, my lord.
Who are the petitioners? Who have voluntarily resigned?
My lord, the petitioner is the I am a Mandal district president, my lord.
Who, number of the petition number 1, 2, but who are the petitioners?
My lord.
Out of 11.
11, my lord.
You have annexed documents
Yes, my lord.
as against whom?
My lord, petitioner number 3.
Huh?
Number Number 3,
3, 7, 8, 9, 10, and
Huh?
11.
3,
7, 8,
Seven.
9, 10, and 11. 6%,
8,
sir.
3, 7, 8, 9,
10 and 11.
10 and 11.
6%.
Okay, by this IA, you have brought their resignation letter on record.
yeah, record,
Right.
my lord. Along with us, we serve the so cause notice
Ah,
to the party also, my lord.
okay.
When
When did you file this IA?
I was served, my lord,
Interlocutor file for vacating the interim stay order. Whether saying so?
my lord, I was filed 18/9/2024. This order was passed on the 2000s, 16/8/2024. My lord, dear, the series IA series number annexure 2 and series page 22. This is so cause notice to serve all the petitioners also, my lord.
Yes, records you have received.
Records lordship is here, lordship. It's here, lordship.
Ah.
And so far resignation is concerned. Resignation is addressed to the president concerned, lordship. It's not to the deputy commissioner, lordship.
Ah,
But
resignation.
Copy was lordship that was marked to the deputy commissioner, lordship. While considering this lordship. Proceeding.
Because yes, they have to address, I think, to the party only.
40%.
Ah.
As per the law, my lord, as per the law, this
because they have
resignation
to
should be
submit
submitted before the president
the
only.
party only.
After that, party president, duty of the party.
Party president only.
Party
Yes,
president only.
Ah.
yes, yes.
Yes.
Or to the deputy commissioner.
No,
They are not under deputy commissioner.
No.
Yes. Do you have the origin?
Pardon, my lord?
Do you have the origin?
Actually, my lord, this is the same through the WhatsApp. Original not submitted to us before the death office. Only those are through sent to the WhatsApp, my lord. So that we will print out. After that, we serve the so cause notice also. But they have no any reply, my lord.
No, where is your so called notice?
My lord, so cause notice is, my lord, please see the page 22 of the my miss case.
Which case?
Yes.
IA.
Yes, I am, my lord. Page 22, annexure 2 series, my lord. This is so cause notice that I am convey that your activity upload in the various social media, my lord. Thereby define the party and the party high command.
No, sir, this is prior, this so called notice is prior to the resignation letter.
Yes, my lord. Before the death, after that, we have they are doing the anti-party, my lord. So that we the advance we serve the notice. Don't such your
That is so called notice, I have understood. But
Yes, sir.
your case in the IA,
yeah
you have based your case on the resignation letter,
resignation letter, my lord.
main ground,
Yes, yes, my lord.
which is under section 3 within bracket 1,
One, my lord.
subsection 1.
Yes.
They have voluntarily resigned from their membership,
Yes, my lord.
right?
Yes,
So this so called notice was prior to that, anti-party activities,
yes, my lord.
right?
Yes,
Those two things are different.
yes, my lord. Difference, my lord.
Now you have annexed the Annexure 2 series, which shows that they have tendered their resignation.
Resignation. Now this is so
Right.
Yes, my lord.
Then whether thereafter any mention of it anywhere,
What is this annexer 3 series?
This is the complaint before the member secretary, my lord. After they have resigned from that party.
Let us see content.
Yes, my lord.
There is nothing, sir. Where it is mentioned? In which of the cases voluntary resignation? Where?
My lord, here is the paragraph, serial number 4, my lord. The Pakistan District Disciplinary Action Committees has passed a suspended orders dated 2/2024 against the Bado Nawam for the violation of the articles number clause 2 of the clause A, B, C of the constitutions of the Bharatiya Janata Party. They further expel from the evoke the order clause 2 and 3 of the article 15 of the approval of this
Right.
committee, my lord.
Where is the mention of this voluntary
Yeah,
resignation?
my lord. Therefore, the fact and circumstances, your office may please to evoke the order, the section 3 of the Arunachal Pradesh Local Authority Provision Act against the Sri Bado Nawam set up as a BRT camp, Sheikh 1, 2, Pakistan.
Out of 11,
For the disqualification of the ground of defection of the, my lord, yes, separately, they we
sir, out
Yes,
of
sir.
11 petitioners,
Yes.
you have said 6 have tendered resignation, whatever, by WhatsApp or whatever,
Yes, sir.
right? Out of 11, 6.
6, man.
Now you have submitted an applications
Yes, sir.
before the member secretary. You have annexed how many? 1, 2, 3, 4, 5.
5, man.
In these 5, there is no mention
No, no, sir.
in the application that they had voluntarily
Yeah.
resigned.
Yes, sir.
Then where from the deputy commissioner has recorded that fact?
Yes, sir. My lord.
Yes, all the notices are available. That member secretary Gram Panchayat, which he has annexed as annexer 3, and where the deputy commissioner also mentioned about 26/6/2024 in his order. Your so-called notice, these are, some things are subjective, but Act says if he has voluntarily resigned under section
Yes.
3(1),
Yes.
out.
Yes.
Okay.
Yes, sir.
And under section 3(1)(b), if he votes, there is no voting.
Yes.
If he abstains from voting, that is also not there. Right?
Yes, sir.
Intentionally remains absent from any meeting, that is also not there. Jila Parishad, Anchalik Panchayat, Gram Panchayat, contrary to any direction issued by the political party to which he belongs. So, under section 3(1)(b), the case of the petitioner may not be covered. Prima facie.
Yes.
Under section 3(1)(a), perhaps the case of 6 petitioners may be covered. But where is the, you said now, WhatsApp? You said WhatsApp,
Yes, man.
right? Thereafter, where is the mention that you have voluntarily tendered resignation and sent it through WhatsApp? Where is that? He is coming up with
Yes.
submission that these are forged,
Yes, sir.
right?
You're right, man.
So tell me, in the application, this application Annex 3 series, you have Annex 5. There is no mention about
Regarding of the resignations,
resignation.
my lord.
You have Annex only 5
5, my lord.
as Annex 3.
Yeah.
Where from we know?
Now here only for my lord, due to some lack of that confidence, knowledge of that writing up, miss out, my lord.
We are trying to find out that
Yes, my lord.
everybody will allege something and everybody will deny something.
Yeah.
We'll have to decide on the basis of materials, convincing materials. Who is the convincing material? Had it been the original been there with the signature in original, it could have been accepted. Now you have come up with that, say that what's up? Difficult to.
They're only for the, that is fine, tell the fact, my lord.
Has been
They
also
said
designed.
only
Where
for
from?
PDF file on the social media in the WhatsApp.
Yes, sir. Anything is available in the record.
For this
We have seen only 5 of the applications.
Yes, ma'am.
Where is the rest of rest 6?
exclusive for
It is difficult to decide on it.
Yeah, my lord, the rest of the not give up their membership, that
Huh?
I tell to fact. That,
Show me the 6. Interim order may be vacated in case of 6.
Yes.
If you give us convincing material. T1B is a bit difficult.
my lord.
These are elected members.
Elected member.
Yes, Your Honor.
Elected members. Just because
Elected member
suppose the district president does not like their faces.
Ah.
He may issue a notice. I don't like his face. Let him be out of the party and put the blame anti-party activities. Now this is difficult to prove.
Yes, my lord.
If they have voluntarily resigned, meaning they are not interested in that party's activities.
My lord, so that
Where is the other 6, sir?
my lord, so that the others, the 11 petitioner is there. So
Out of
react-
11, show me convincing material about 6.
but 6 is my lord, here only 3
What's
parts,
up?
their resignation, my lord.
No, you should have been put them to notice that yes, you have sent it. What's up?
So,
Oh, sir, please come to your applications. Annex 3 series.
my lord, Annexure 2 series, this is the resignation, the throw that
2,
was
sir,
that PDF file, my lord.
you
That,
produce me the original, I am ready.
my lord, the originals, they are not submitted.
You have said, what's up?
They are only for throw PDF file sent in WhatsApp, in the party office.
Then you have to get the certificate. Under section 65B. The Evidence Act.
Yeah.
And from which mobile to which mobile?
Yes, yes, exactly.
These are required.
Yes, yes, my lord.
But
Exactly.
after that,
Exactly.
Annex 3 series. Did you mention anything? No.
No, my lord.
Where are the other? Where are the other 6? You have Annex 5 only.
5 only, my lord.
Who is the petition number? 3. What is his name? Carling Natung.
Already.
Let us see Carling Natung is there or not. Annex 3 series. Baba, Bado, Bampu, Sango, Naga Kechi. No, his application is not there. Then next is petition number 7. Bado. Bado is there.
That was there, my lord.
But there is no mention.
No mention, my lord.
I think better to have this petition, I have to be dismissed.
My lord, actually, this is a
Well, the petition is to be heard.
as well.
Because 3(1) B
3(1)(b).
In absence of any convincing material against section 3(1)(a) regarding voluntary resignation, case is to be considered under 3(1)(b). Anti-party activities.
My lord.
Yes.
We were being disqualified without giving any opportunities. After disqualification from the deputy commissioner, and Your Honor, Lord, we have submitted a protest petition. After getting stays from this honorable court, and out of nowhere, the interim was filed by the Mandal president, and there our resignation letters were annexed, as mentioned by this learned seniors.
Yes, Mr.
But-
Counsel, 1 minute.
Yes, sir.
Come to annex 3 series again.
Yes, sir.
Para 3. That on the notice of uploaded defaming statement of Sri Bado Nabam
Nabam.
against the BJP and High Command on social media, the President,
President 2, Pakistan.
that sentence is also incomplete, right? Where is the uploaded material? Where is the defaming statement?
I know that's there due to some lack of the knowledge also. Just I'm make though they have no any legal idea how to write that clearly mentions.
No, we are not on it. We are on the material.
Yes.
Material should be available, right?
My lord, this interim was filed on 18 September 2024. After knowing this, we have filed an FIR at Pakistan Police Station.
And
For-
what is this? What is this? What is this judgment?
My lord, this is judgment of that disqualified of the Jilla Parishad members of the key Panjab district. Now similar measures has been passed by this honorable double bench or disqualified of the Jilla Parishad member, madam.
But in your case, WhatsApp only.
Yeah, this is only put through WhatsApp. But
Is
this
it in case of WhatsApp?
No.
No. And
They are only put, actually, my lord, the petitioner, they have not come to our office. After we serve the show cause notice also, after that show cause notice, they have give their resignation through WhatsApp, my lord.
you file your response
Only
in
by
the
the-
petition. Have you filed? Have you filed your counter affidavit in the writ petitions? Huh?
Actually, not to copy.
In the main petition?
No, till no file.
Oh, you filed? I'm not very convinced in this
Oh, sorry.
for vacation of the interim order. You have, your case is, one of the ground is that a provision for disqualification under section 3(1)(a).
3(1)(a), my lord, only two.
That is not, there is no convincing method. I have to hold that way. In the Annexer 3 series, 20. I think the entire petition should be heard. Instead of piecemeal, anything
Lordship,
in the record.
Here in record, Lordship, application for disqualifying all the Lordship petitioners are available also. But in their Lordship, the so-called resignation part is not there. And apart from that, those resignation letters are here Lordship. How Lordship it came to the deputy commissioner, that part also is not clear.
No, as per the provision of law that CEO or AC is the member sector of Panchayat members.
I have
After the-
understood. But this, after that receipt of letter through Bacha, there should be a clarification from the petitioner that you have sent letters to WhatsApp and giving your resignation. So called. Why? You should not be
Yes, unable to establish my left.
expelled. There is some mention, then they would have responded. Who else have filed affidavits?
Lordship, respondent number 2.
Respondent number 4. And respondent number 1.
From our side, we have already filed. If Lanet.
Yes, Mr.
Private respondent.
Respondent number 5 and 6 want to file, they can file. Heard, Mr.
Arpitra.
R.T. Tara, Learned Counsel for the petitioners. This is item number 334. 718. Okay. Two petitions. Two petitions. Why? Okay. Your name, please? T. Petitioner counsel?
He is in IL also, he is for respondent.
No. Indirect petition.
Main petition. Arup Tichitara.
Okay. R.T. Tara, Learned Counsel for the petitioner, and Mr. So-and-so, Learned State Counsel for the respondent number?
Lordship 1, 2, 3.
1, 2, 3. And Mr.
P. Women.
Learned Counsel for the respondent number 4 and 5. 5 and 6. 5 and 6. Five and 6?
Hello, 5 and 6.
Check yourself.
5 and 6.
Last time also, what happened? NHAI. That's the previous case. Deputy Solicitor General of India have accepted notice on behalf of a national highway also.
Yes.
The previous case. You represent 5 and 6 or not?
He's for 5 and 6 also.
5 and
Because
6.
IA has been filed on behalf of 5 and 6.
Okay. And this respondent number 4?
4 is Lordship by person, I think. Is
All right, you cannot represent whether notice has been served or not.
that part Lordship.
Huh? Yes, Mr.
Yes, sir.
Sir.
Pro member secretary. This deposit commissioner is included. Member secretary CEO.
Okay. The respondent number 4 has also been served by way of Dusty. First up. Mr. So-and-so, Learned Counsel for the respondent number 5 and 6 are allowed. How much time?
2 weeks.
2 weeks time to file the counter affidavit on behalf of the said respondents. First up.
My lord, interim may be continued.
The interim order passed earlier shall continue till the next date of listing. And I heard Mr. So-and-so. learned counsel for the applicants, that's response number 5 and 6. Mr. R.T. Tara, learned counsel for the opposite party, that's lead petitioner, number 1 to 11. Full stop. After having heard the learned counsel for the parties, this court is of the considered view that the interlocutory application is to be considered along is of the considered view that instead of hearing the interlocutory application, comma, the main petition is required to be heard after exchange of pleadings is complete. Full stop. Para. The Mr. So-and-so learned counsel, it will last to leave it. For the applicants, that's response number 5 and 6 have submitted that the instant interlocutory application is preferred seeking vacation of the interim order dated 16/8/2024 passed in the connected with petition WBC number 334 within bracket AP stroke 2024. Full stop. The interim order dated 16/8/2024 comma the impugned orders comma dated 22/7/2024 passed by the Deputy Commissioner regarding disqualification of the petitioners have been stayed. First off, Mr. So-and-so learned counsel for the applicants have submitted that six out of the 11 opposite parties, that's read petitioners, comma, that is, comma, petition number 3, petition 7, 8, 9, 10, and 11 had voluntarily tendered their resignation from the party on 11/4/2024. And in such view of the matter, comma, the provision of section 3 within bracket what is the act? Page. What is the name of the act?
Arunachal Pradesh,
Arunachal Pradesh Local Authorities Prohibition of Depiction Act.
Page
75. 175.
175. Section 3,
Section 3,
1, small a of the Arunachal Pradesh Local Authorities within bracket Prohibition of Defection bracket close Act 2003 within bracket 2003 Act is automatically applicable. Full stop. In respect of their case. Full stop. Subclause A of section 1, subsection 1 of section 3 of the Act 2003 has internally provided that a member, comma, belonging to any political party, comma, shall be disqualified for being such member if he has voluntarily given up his membership of such political party. Full stop. Para. On a query made to the Learned counsel for the applicants. Mr. So-and-so has submitted that the resignation, copies of the resignation letters purportedly tendered by the petition numbers 3, 7, 8, 9, 10, and 11 were received through WhatsApp, and the resignation letters in originals were never received by the district president, Pake Kesang District Unit, BJP, to whom the resignation letter were shown to be addressed. Full stop. Para. In the applications made to the member secretary, Gram Panchayat, Pake Kisim Circle, by the district president, Pake Kisang District BJP, purportedly as a complaint under Section 6 within bracket 1, Section 6(1) of the Act 2003 on 26/6/2024. There was no mention as regards the tendering of resignation by the petition number 3, 7, 8, 9, 10, and 11. Full stop. In the above backdrop, this court is not inclined to vacate and stroke modify the interim order passed on 16/8/2024, passed 16/8/2000, in respect of the petition number 3, 7, 8, 9, 10, and 11, much less against the other petitioners, not to speak of the other petitioners. First, and consequently, the interlocutory application. This court is of the privacy view that the interlocutory application on such facts, pleaded facts, cannot be allowed, and accordingly, it is dismissed. It is, however, observed that the observations made in this made herein above shall not be construed as observations as regards the merits of the claim of the petitioner in the connected with petition. Dismissed.
Abhilash.
Here, Your Lordship, we have filed on behalf of respondent number 4, Your Lordship. But for respondent number 4, we have filed, Your Lordship. But for 2 and 3, we will be filing, Your Lordship.
You need time.
Yes, Your Lordship.
Okay. Mr.
M. Tasso. M. Tasso.
Land Conservator petitioner is present, Mr.
Wairi Ram.
I'm not remembering the name. Mr.
Wairi Ram, Your Lordship. 1, 2, 4, Your Lordship.
Sir, explaining. Huh? I mean, given the list, but not the, your name is not there. Huh? Oh, that's it. Why? Okay, why Ram?
Yes.
Learned. Junior government advocate. As paid for 3 weeks time to file, to obtain necessary instructions and to file counter affidavit on behalf of the respondent number
2 and 3, Your Lordship.
2 and 3. This is the price allowed. This is the case after 3 weeks.
Oblige, Your Lordship.
20 and 21.
Here, Your Lordship, we have not been furnished with the extra copies till date, Your Lordship.
Oh. It appears so.
Your Honor, I'm for the petitioner. Yeah.
Maybe he is not interested. Huh? Tender matter. No interim.
Interim is there.
Hmm?
Interim is there. Stay.
Huh?
Stay is there.
Then we'll vacate.
Your Honor, they are supposed to file,
Huh?
respondent supposed to file this reply.
Since September 2024, you have not furnished extra copies to the State Council. So it should be vacated.
Your Honor, we will furnish. Now it's
September 2024. Since September 2024, you are enjoying an interim order. Right?
yes, Your Honor, actually I'm
And
appearing.
you are supposed to serve all the copies during the course of that day. September and October, right? 27/9/2024 and 3rd October 2024. Extra copies during the course of the day.
Your Honor, actually, right now I'm appearing on behalf of this leading counsel. He's in the another court, so he has approached me to appear because the respondent is yet to file his reply. He have instruct me. If matter is going to vacate the
Subject to
let's
the
say then matter may be passed over for time.
no penalty should be issued with the kind of order. We introduce this order. Has been cancelled. Yes, have you filed any? Oh, no. You serve copies by tomorrow? In the event of failure, the interim order stands modified. States will stand recorded. None?
Done.
Okay. Mr. Hart, Mr.
T. Njuma.
Now, counsel for the petitioner and Mr. Y. Ridam, junior government advocate for the respondent number
1 to 7, Your Lordship.
1 to 7. Post of Mr. Ridam has submitted that in item number
28.
20, huh?
28.
449, has submitted that after the order dated 3/10/2024, wherein an interim order was also passed, comma, the petitioner had not furnished requisite number of extra copies of the petition along with the documents appended thereto. Full stop. Para, it is noticed that by the order dated 3/10/2024, the petitioner was directed to provide extra copies of the writ petitions, requisite number of extra copies of the writ petitions, along with the documents appended thereto to the Land State Council during the course of that day itself, within bracket 3/10/2024. Full stop. More than 6 months. 6 months or 6 months have elapsed. But the petitioner has not taken any steps for service of, supply the copies of the petition to the Land State Council. Also, Mr. So-and-so Land Council for a petitioner has undertaken to serve the extra copies of the petition along with documents appended thereto by tomorrow. The prayer is allowed with the observation that in the event of failure on the part of the petitioner to serve the extra copies of the petition along with so-and-so by tomorrow in terms of the order dated 3/10/2025, the interim order passed on 3/10/2025 4 cell automatically stands recalled without any reference to this code. Similarly, item 21, interim order is different. It is 27/9/2020. Right? Place the case, please, after 2 weeks. I think 3 weeks.
Yes,
3 weeks.
24, 25.
Yes, sir.
Yes, my lord, this is a NIT floating of tenders, my lord.
NIT.
Yes, my lord. So, my lord, this is NIT was impacted by that RD departments, that the rural departments, under the project director of the UPA, PD. After the floating tender, I was participated. I was, my lord,
Affidavits are exchanged.
my lord,
Your Lordship, order dated
yeah, yes, my lord, everything I have received, already received, my lord.
We were asked to seek some instructions, Your Lordship, by this.
Okay.
We have received, but.
Received?
Yes. But we will file it in the form of additional affidavit, Your Lordship.
You'll like to file it in the form of additional affidavit?
Yes, Your Lordship.
Okay.
Because the thing is, Your Lordship, the.
Respondents shall file a take the recruitment process. Okay. And why locus is issue locus?
My lord,
Non-joiner of necessary.
In the last order, some issue of locus is kept open. Anyway, you want to file?
Yes, Your Lordship. Within a week, Your Lordship.
my lord, that matter may be fixed for the particular date because of that is an urgency matter for the tender for the. This is a Film Institute of Arunachal Pradesh, my lord. Actually, my lord,
Number 24/25.
but my lord, yeah, the
Outsource agency.
yeah, outsource agency, my lord.
Yes, Your Lordship.
I have, my lord, the L1s. I have a letter of intent that I have already submitted the security deposited that before the PD of the project directors. All the tender formality has been already, my lord, completed. But all of a sudden, my lord, without any opportunity given me, my tender was cancelled.
Cancel?
Yes, my lord, cancel, my lord. Please, my lord, MP more than my lord. Without any giving opportunity me, tender was cancelled, my lord. After my deposit of security, bank performing grantee, report that authority, that all of a sudden, without any give opportunity, my lord, cancelled.
Okay, let them file the additional affidavit, sir, because it
My
was
lord,
observed.
my lord, this application is very clearly stated that.
No,
Very clearly stated that only for the motivate of the political influence, my lord. Though due to pressure of the respondent number three,
Sir,
that
in
is
the
deputy
previous
commissioner filing
order,
only.
previous order, court has directed them to file an additional affidavit.
Yes, my lord, the MP motor page 56, my lord, my petition copy, my lord.
No, I am looking at the previous order.
My previous order is only, my lord, after the cancellation of my tender, yeah, another inviting for that other department, that the UD department. That without any go for formality, another the direct recruitment, my lord, that the UD departments.
As per our instructions, Your Lordship, the recruitment process is already completed and appointment has also been made. And they are drawing the salary for the last month, 1 month. Your Lordship.
My lord, after this,
And Your Lordship.
hardly departments was completed of their
Tender for
NIT.
selection of outsourced agency for engagement of contractual staff for Freeman Television Institute pursuant to the NIT Drill so letter is issued to has been cancelled on the ground as due to complaint of some part of the agreement in between the PD. PD means?
Project Director, Your Lordship.
Project Director, rural.
Where is the MP order? Where is the MP?
My lord, page, annexure 8, page 56, my lord.
Annexure 8, page 50.
6, my lord. My lord, page 55, annexure 7 is my bank gratuity performance deposited to before the project director of the rural departments.
So it was letter of intent.
Yes, my lord.
Not, there was no execution of contract agreement.
No, my lord, the agreements was not enough, but my lord, little is only ground is that complaint of the landowner said. Whereas, my lord, total member of the landowner was 27, my lord.
Then what is this urban development, district urban development agency?
This is the, my lord, government department.
Water nodal agency has already advertised walk-in interview
Yes, my lord.
for various posts of FTI.
Yes, Your Lordship. Earlier, we were.
So new person has been engaged.
Yes, Your Lordship. It's the government
That
agency.
is my case, because that is, I have filed another writ petition also, challenging the death orders, my lord. Another writ petition also filing, my lord. My lord. The warehouse matter is already pending the before that your PD without solving. Again, that advertisement to another, appointment to the another department, that is UD, my lord.
Yes.
Whereas, my lord,
Yes, tell me now, for a letter of intent holder,
yes, my lord.
what are the rights?
Pardon, my lord?
As a letter of intent holder,
Yes, my lord.
what are the rights?
Uh,
Legal rights
yes, my lord.
to get the contract executed
Yes, my lord.
by approaching before a writ court,
Yes, my lord.
by filing a petition under Article 226.
Yes, my lord. So, it is why, my lord, the,
Rights.
yeah, right, right, my lord. My lord, I have fulfilled before the authorities, as per the competitive bidders. I am the one of the bidders, successful bidders. After successful bidders, I have a allow for the.
Okay,
L1.
what are the rights?
My lord,
If the authority
yes,
decides not to proceed to the level of execution, to the stage of execution of a contract,
yes,
and decides to proceed for engagement of the required personnel
yes.
through a nodal agency of the government.
That is, my lord, I come to point that the state government of Arunachal Pradesh has been appointed as a nodal officer of the RD departments. State government of Arunachal Pradesh has been appointed as a nodal officer at the department of the RD of the UPI districts. Thereafter, he has.
Tell me the rights. Then I'll agree with you.
Yes, my lord. No, I come to
The
point.
letter of intent, I have understood.
Yes, ma'am.
You have NIT was issued.
Yes, ma'am.
You participated.
Yes.
You fulfilled all the conditions,
Yes, ma'am.
right? And letter of intent was issued to you. Thereafter, ultimately the contract agreement was not executed,
Not executed.
right?
Yes, ma'am.
Show me the stage between letter of intent and contract agreement.
Yes, ma'am.
What are the rights for the petitioner to get the contract agreement executed
Yes, ma'am.
with the employer?
Yes.
Can the writ court bind the employer
Yes, ma'am.
to enter into the contract agreement with you? Tell me that.
Yes, ma'am.
I have accepted, you have fulfilled all the conditions of the NIT.
Yes, ma'am. Yes, ma'am. Yes, my lord, so that I make annexures.
Show me some
Yeah.
decisions.
So that, my lord, I am ready to be accept the term and conditions.
I have already accepted, sir.
Yes, 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 ma'am.
I have already accepted. You have fulfilled all the terms
Yes, ma'am.
of the NIT and reached the stage of letter of intent.
Yes.
Thereafter, I have seen the NIT. That is why I have seen. Thereafter, what right you have to get the state government entered into a contract agreement through a writ petition under Article 226. You address me on that point.
Now, my lord, as per my agency, I ready to be appointments for the recruitment policies as per the guideline of as per the Film Institute of Chhattisgarh and state of Arunachal
Okay,
Pradesh.
take up tomorrow.
I ready to do.
Go through letter of intent.
I ready to do appointment to both.
If they have decided to not to proceed further with the NIT and have decided to engage the personnel directly through a nodal department,
Yes. Yes.
may seek damage perhaps. That will be not before this court. Ready tomorrow?
I am ready to, my lord, the recruitment process if the letter of intent is executed.
Please
Yes.
bring all the decisions on letter of intent.
Yes. The way the letter is executed for the state governments versus between the.
Yes, please
me
bring
and-
all those
Yes, sir.
letter of intent decisions.
Mm.
Please bring all the authorities on letter of intent.
Yes,
Have you understood my point?
we understood.
Okay, you also. On letter of intent.
Mm.
Mere issuance of, whether issuance of a letter of intent means agreement.
Agreement, my lord.
Whether they have the authority to cancel the contract or not. Right?
My lord, here I submit before the representation also.
You answered to these two issues, that's all.
Yes.
Okay, tomorrow?
My letter of intent, my lord.
You
also-
I'm confused. That is why I have requested you to bring the authorities on letter of intent. Have you understood? Am I been able to convey?
Yeah.
Please
Yes.
convey my
Right.
confusion to him.
Mm.
Okay,
Mm. Mm.
make a research,
Yes, my lord.
come tomorrow.
Mm. Okay, my lord, let's, day after tomorrow, my lord.
Huh?
It will be fixed for the, I will be bring all that.
On the prayers of the Learned Council for the parties, these the cases, day after tomorrow.
Day after tomorrow. My lord. 26. Same metric, yes.
My praise lordship, my lord, may I pray, my lord, the item number 27, my lord. And the order passed on 9/4/2025, my lord. In terms of that, the matter has been listed today. So if lordship takes up item number 27 first, my lord. 9/4, lordship, the order was passed. Item 27. my lord. No.
Yes.
9/4/2025.
9/4.
Yes. Last order, my lord. The learned, my lord, standing council was asked to bring the, my lord, documents which
Seems to documents, numbers, points. Yes.
Yes. My lord, may I get 2 minutes, my lord, because this one matter was heard, my lord, for some time, last time also, my lord. I'll just try to explain, my lord, what's the context in which this matter has gone now. What happened, my lord, this is a vibrant village program. NIT was floated under that one.
NIT?
Yes, ma'am. So what happened, my lord, I'll just, without going through the documents, my lord, the gist of the case, ma'am.
The name of the work only.
Vibrant village,
Name of the
lordship,
work.
yes.
Name of the work only.
Yes. Lordship, may kindly,
Construction and maintenance of roads.
yes, it starts from page 30, lordship.
Okay. Construction, maintenance of roads under vibrant village program.
Yes.
Okay.
So what happened, my lord, I participated in, there were many tenders, my lord, concerning to that particular area with the concerned authority, same authority, my lord. So I participated in two, three tenders, my lord. So what happened in this particular tender, the government said in my technical bid, my lord, I've been disqualified, saying that this condition, that condition you have not fulfilled. Therefore, your bid has been declared non-responsive in the technical that one stage, my lord. So I was not called for a prize bid. So I have, when I challenged the matter, my lord, by that time prize bid was also open and the award has been made to a private respondent. So now, when I participated in so many tenders, particularly with the same authority, for same set of documents I provided, but I didn't provide any other document. And another tender, my lord, the same authority accepts that bid, man. And I have been declared responsive and I have been awarded work, man. Now, whether the only moot question of that, so many allegations are there, man. We leave it, I'll forego all those allegations. I have level allegation against the private respondent. The government has leveled so many allegations, but there cannot be two standards, man. When my bid has been accepted in one of the tenders, madam, but the same authority, if the authority was different and same kind of project, madam.
Where is the technical bid rejection order?
Yes, madam.
Evaluation?
Yes. Madam, it's page 121, madam.
121.
Yes.
Hmm.
So, madam, operative
You are
push.
empty agency.
Yes, madam. Non-responsive.
Clause 4.
Yes, all these,
41.
madam.
Where are those clauses?
Those clauses are there in the, madam, I have annexed those. It starts from the bid documents, madam. Kindly see page, starts from page 42, lordship.
4.4B.
Yes, lordship.
4.4B.
4.4B.
1. Roman.
Small I, madam.
Small
B,
I.
yes, ma'am. That availability of construction on either own or my lordship got the page 42, lordship. Last line.
Each bidder must produce.
Yes, madam.
4 B 1.
Yes.
Must demonstrate.
Yes.
Must demonstrate availability of construction work either owned.
Yes.
Or on lease or on hire.
Yes,
of the key equipment
Stated in the
appendix to ITP, including equipments required for establishing field laboratory to perform
Yes.
the mandatory test and those stated in appendix to ITP.
Yes.
Then annex appendix clause 4.4B to Roman 2.
Yes, that is the
Roman
page 43, lordship.
43, ability for construction of work of
Technical personnel.
So and so.
So first is for
Okay.
machinery and second is for technical personnel.
Then 4.7.1.
That is, my lord, if apart from this, even if I qualify everything, my lord, the government has the authority has the right, my lordship will say, page 44, lordship. 4.7. Lordship, even though the bidders meet above qualifying criteria, they are subject to be disqualified if they are, lordship, got the page 44, lordship. Made misleading or false representation in form, statement, affidavits, attachment, submitted and proof of qualification requirement and or record of poor performance such as abandoning works, not properly completing the contract in order to delay it in completion, litigation history or financial failures, etc. So,
Scan copies.
May I, Lordship? Your Lordship, today only I filed the wakalat number. Day before yesterday only the private respondent number 6 has engaged me. So today I filed wakalat number.
Malad, this
I need
Malad, this inordinate delay will Malad, defeat my writ petition, Malad. Because as the time goes, they will be coming up. They already have taken the plea. We have substantially.
No, who is this one of C, sir?
6 is Your Honor. Your Lordship, TNT Enterprise, Your Lordship.
Successful. We have.
Successful is okay, but in the previous order, scan copies were for.
Yes, I have, before documents. Admittedly, only documents which are used are saved, but they use same set of documents that we are not denying. But these two packages, which is before this honorable court, which they have challenged, these two packages were evaluated on 2nd August 2024. They have furnished same set of machinery, same set of technical personnel for two packages for two different divisions. So therefore, it was rejected. And other one which he had claimed that on same set of documents, he has qualified in one package. That was evaluated in the month of 20th October 2022, after gap of more than 2 months. So
28 October.
yes, in October evaluation, he
No, in how many packages he participated?
almost 3 packages.
3 packages.
2 packages was evaluated in the month of August, 2nd August.
August
Right.
2024.
24. And he has furnished same set of documents. So into division, he cannot engage one technical person into the packages if what is success. That is why they have rejected on the ground of insufficient machineries and technical person, same set of technical person.
Oh,
And other aspects, there is also allegation of documents which they are furnished was paid, invoice.
point.
This is a repetition 619 and 619
One.
is implemented.
So you want to say that the bids which were evaluated in August
August,
2024
yes,
in respect of 2 separate divisions,
2 separate.
both were rejected or found non-responsive.
Non-responsive.
But however, at a later point of time, in October, when another package was considered, then it was
Since there's only one package.
This lordship can understand what kind of malad.
no.
Malad,
Ultimately, it is the employer who has to see.
No.
Ultimately it is the bid capacity also.
no.
It is the bid capacity.
No.
Where is the formula?
Malad, that is not the ground they have taken, malad.
Whatever.
That's not the ground.
They have the power to consider everything. Whether it is arbitrary or not.
That's why, malad, arbitrary.
Position is arbitrary or not.
Totally arbitrary. Lordship may kindly appreciate these tenders were not floated at different date, malad. It was floated on the same date.
Any minutes recorded. Any minutes recorded. It is.
Yes, recorded, this is one which he has qualified.
No. In the, this is technical, this bid evaluation report.
Yes, here also they have recorded. Page 121.
Some regions are recorded somewhere else.
They have given the clause, under which clause their bid has been. So it has clearly mentioned in the SBDs, all these clauses. Otherwise, my lord, at this stage, although he has challenged the tenants up to financial bids, what is it about that? Education is.
And you are not the only one.
You.
Malad.
You are not the only one chosen.
Yes.
ZB Enterprise, RTT Enterprise, HB Enterprise, Ragia Enterprise, all were found non-responsive on the count 4.4,
Yes.
B1,
Yes.
B2, 4.71. Some are also on 24.2. So you are not the only one.
Yes, they have no challenge, man. I have challenged before some. That's different, man.
Now, they have filed their affidavit.
Yes, government has filed. That government is not denying that fact, my lord. First of all,
He is not denying.
yes, that's fine. Now, lordship will kindly appreciate whether he agrees that it's the same set of documents, my lord. And the date of your lordship.
The bid evaluation team.
Yes.
Is the same for the 2 separate divisions?
Same authority. Same authority.
No. In August.
Same.
Separate divisions, okay.
Same authority.
But the committee, bid evaluation committee is the same.
Same. Malad, that's a bizarre, malad. How much same?
Not bizarre.
It's
not bizarre. It cannot be bizarre.
Lordship, same authority, even it were a different authority. it may-
Bidjar is when the cow climbs on the tree.
Malad.
Right? It could be
I don't know,
said.
Malad, if I'm able to.
Maybe discriminatory or arbitrary, not Bidjar.
In my humble opinion, it's a bizarre case, Malad, where the same authority.
No.
It
Cannot be Bidjar, yes.
has a different.
Maybe they have some region, but two separate division. How far is the distance?
Distance,
Malad,
And what are the affidavits? What are the
affidavit.
affidavits?
have some more allegation, they furnish check document, but he has not replied. That means he has admitted.
I'm not, Malad, I'm on this, that sole ground, Malad. When they have not denied, Malad, I did not reply to Malad. They have not denied my allegation, Malad, in the affidavit.
Tell me, just for the satisfaction of the court,
Yes.
what is the price bid of the successful bidder?
Price bid, Malad.
Price,
Yes.
the award.
Page 315, Malad.
315.
Yes.
What is the award? Okay. Okay. Now, what was your bid value?
Malad.
What was your bid value?
My bid has not been opened, Malad. That's why.
You know,
I have no instruction, Malad, frankly, Malad.
see, we are not going into academic exercise.
Yes, Malad.
If your bid value
Yes.
is lesser than at page 316,
Yes.
their bid value is 25 crore, 34 lakhs.
Yes.
If your bid value is 28, crores perhaps or lakhs, whatever. If your bid value is 28, say,
Yes.
no point going into all these aspects.
I admit to that. I admit to that. Yes.
No point.
Yes.
It may be left open for another round. If your bid value is say 28
Yes.
and L1, because there is no allegation regarding L1,
No.
right? You have not brought any allegation.
No, I have brought, but Malad, no, it's that's why Malad.
Not sustainable.
No, Malad, I wanted to shorten the matter.
Yes,
because
right.
The time,
Right.
paucity of time, Malad. That's why.
Right. You take instruction on these two values. See, if firstly you have to make your case on L1
Yes.
that he is to be ousted. We are not making any point. We have to see whether this petition is to be allowed or not allowed.
Yes, Malad.
Right. Now, first, whether L1 is deficient.
Yes.
If you can successfully put it, then you have a case.
Yes.
Then whether your bid value was lesser than L1,
Yes.
then only you have a good
Yes.
case. Maybe.
If your Lordship allows me, can I just give you alternatives, Malad, suggestion, Malad? But I'm praying basically is, Malad, the technical bit that has been rejected, Malad, my case, Malad, that may be set aside and required. And your Lordship may direct the authority, the board, to open my technical bit and decide according to the discussion may be left to them, Malad. That alternate period,
You
no,
come up with your statement.
Malad. That
No point
Just my
for this exercise, huge
No.
exercise.
alternate
No
such
point.
as suggestion, Malad. No, your Lordship may not accept it, Malad.
Yes.
Yes, Malad.
No
That's
point.
why. Then
No point for a huge exercise like this.
yes. Then it
When the award has been made,
yes.
work has progressed to an extent.
In this case, Malad, this particular, that's why last time my Lordship order is reflected. In March only they started the work, Malad.
Whatever,
No,
please
yes.
get your instruction on the two packages, whether your bid value
Yes, sir.
was lesser than the
I'll do.
L1 value.
I'll do, man. Yes.
right?
Can the matter be listed tomorrow or Malad?
It's up to you, we can,
Tomorrow, Malad.
tomorrow it will.
Thursday. I can have instruction today itself, Malad.
We'll put it, we'll test it.
Your Lordship, tomorrow not possible because the leading counsel is coming. Yeah,
Malad,
he will be available day after tomorrow, Your Lordship.
Day after tomorrow?
Yes, Your Lordship.
Or you have to say something.
Your Lordship, as of now, Your Lordship, the leading counsel is at Guwahati, so he will come.
Yes,
Yeah.
but whether you have entered appearance, when you have entered appearance?
Today only, Your Lordship. Today itself,
we have no served notice in January, Malad. It's up to them not to enter so late, Malad.
Where is the observation?
Your Lordship, after 2 weeks, Your
The
Lordship.
order, Malad, last time order has already been reflected in. Twenty- 21 to Lordship may kindly see order, Malad. 21 to February. Malad. Order was already reflected. They were already served, Malad. They have now approaching in April, Malad. Intentional that one. Served in January, Malad.
But today they have entered.
Otherwise also, my lord, there are several litigations to deal with. The Indian Parliament proposed they have approached this court again regarding these packages.
No, that's different, man. Not in my case.
Litigation after litigation.
Okay, you complete your instruction, we are giving time.
Your Lordship,
Next week.
my humble prayer is, Your Honor, it may be list up to 2 weeks, Your Lordship.
But that's no.
No, next,
Okay,
next,
1
next,
week.
next,
Next
next
week,
week.
Yes, Your Lordship.
You get equipped your, because you have been served with notice.
Yes, Your Lordship. Next week. Next week. Lordship.
Maybe you were waiting for, from outside, looking at the scene. Huh? When this order has been passed lastly.
Yes.
So you have entered into the arena.
Not exactly, Your Lordship.
When?
Next
Today
week.
is
This 20.
March, April, 23, 22. We put it on,
30.
29, Malad. 30, Lordship. 30 April.
30.
30 April.
Yes.
Okay, 70.
Yes. Both the matters, Malad. 26, 5, 26.
I mean, what, is the instruction regarding?
Yes, sir,
your
definitely,
delivery?
definitely.
Obliged,
I will try, if possible, we'll file a small affidavit.
I am in 26
Yes.
for a private.
26.
Yes.
NT agency, same.
Yes.
Council is the same, Malad.
Petitioners.
Council is different.
No, council is also the same, the private respondent.
Respondents are different.
Okay, you are private respondent.
Yes.
Second
Different.
difference.
Okay.
I am for respondent number 16.
Heard Mr. P. Tafu,
Lordship.
Learned Counsel for the petitioners. Mr. So learned Gitara, learned so for the state respondents. And Mr.
And the panel, item number 20.
D. Pangi, learned Counsel for the private respondent in 26. Yes, Mr. Counsel, your name.
No, but he.
Who is the counsel?
I don't know why he is without passing order. He has vanished. I don't know. A private respondent is a rare name, man. I don't know.
He has found that he is safe. He has gone out.
Maybe he was under the impression since notes it changed next.
No, I'm not familiar with the names. That is why
We also don't know.
it takes time for me.
Even we don't know.
Okay. Mr. Navam Takum, Learned Counsel, has submitted that he has entered appearance on behalf of the respondent number 7 in item 27, in WBC number so and so, and has sought for a week's time to complete his instructions. Full stop. As agreed to by the learned council for the parties, release the case on 30. Yes. Mr. Takul, learned council for the petitioner, shall obtain instruction as regards the bid value offered by the petitioner in the in response to the NIT, two NITs in question. Two NITs or two packages? Two packages. Two packages in question. Two packages involved in these two regulations. Okay. Then only will progress.
Yes, madam. Otherwise, no point. Most is almost complete now.
Academic question, let us see.
Yes. All right.
Other priority. Yes, madam.
Your Lordship, we have taken steps upon response number 6, but it's still awaited.
Awaited.
Yes.
Miss
S. Thomu.
Somu Learned Council petitioner and Mr. Y. Sriram and Junior Government Advocate for the state respondents are present. In view of the office note dated 21/4/2025, await for the service report in respect of the respondent number 6. Release the case after 2 weeks.
29.
Here, Your Lordship, I may be allowed some more time to file our affidavit.
Mr. Y. Sriram, Learned Junior Government Advocate, has prayed for and is granted 3 weeks' time to file affidavit in opposition on behalf of the respondent number 1 to 4.
Yes,
In view of the office note dated 21/4/2025, await for the service report in respect of the respondent number 5. Tarabal Lichibo, first, there is no representation on behalf of the petitioner as today on call. Is the case after 3 weeks.
My lord.
Service report awaited.
Then my lord, I may be allowed to take Dusty, my lord.
In contemplation, the stay is permitted. Firstly, you were late, you took the steps after 1 month. See the report. Yes, there is lapse on your part, sir. This one. You take, if you want, you take 3 steps. Both by registered porter as well as usual process. No Dusty. And Mr. C.
No, NUB.
Learned Council for a petitioner. Mr. So-and-so has submitted in view of the office note dated 21/4/2025, the petition may be permitted to take 3 steps for service of notice. Office notes 3/2/2025 and 21/4/2025. The petition may be permitted to take 3 steps for service of notice upon the how many respondents? How many? Sole respondent by registered post with AD as well as by usual process. The prayer is allowed. The petitioner shall take steps for service of notice upon the respondent by way of registered post as well as by with AD as well as by usual process within a period of 3 working days from today. Okay. This is the case after 4 weeks.
All right.
Yes, why it has been listed?
Here also we need-
5 to 50.
Yes.
Await.
I have received instruction to represent the private respondent.
From respondent number?
5 to 50.
Okay. Your issue is solved. 5 to 50. Then it will be listed for admission.
We have not filed our affidavit yet.
Okay. How much time you need?
3 weeks.
Okay. Mr.
K. Mubam.
Vivang, learned counsel for the petitioner is present, and Mr. Y. Riram, learned senior government advocate for the respond number 1 to 4, full stop. Mr. Riram has prayed for and has granted 3 weeks time to file counter affidavit on behalf of the state respondents. Mr.
B. Padul.
Learned counsel has submitted that he has entered experience on behalf of the respondent number 5 to 50 and has also sought for 3 weeks time to file counter affidavit on behalf of the state respondents. Full stop. Both the prayers are allowed. List the case after 3 weeks in the admission column.
Obliged.
Yes.
May it please your lordship.
Why it has come?
Transfer posting matter, lordship.
Hmm?
Transfer posting matter. Government as well as private.
You are enjoying interim order.
Lordship?
You are enjoying interim order.
Yes, lordship.
Lordship. Have you filed your
Yes, I have filed my affidavit.
reply?
Yes.
Everybody has filed.
And regarding government, my lord, I think the court has been called on.
No, government has also filed their affidavit.
Okay. Okay. Then we can put it on admission column.
Lordship.
Yes.
Huh?
My lord, short date may be fixed, my lord. This is transfer matter.
Okay. When do you want?
Next week. Fix like
2nd of May?
next week. Second.
2nd of May?
Lordship, difficulties. I don't have my diary with me. It has been
Okay.
misplaced somewhere. So lordship, after week.
Okay, Mr.
A Tatak, lordship.
Tadak, learned counsel for the petitioner. Mr. Y. Riam, junior government advocate for the state, respond number 1 and 2, and Mr.
Yes. Arriba, my lord.
Learned counsel for the respond number 3
Yes, ma'am.
are present. As sought for by the learned counsel for the parties, list the case in the admission column after a week. The date to be fixed by the office, the interim order passed earlier shall continue till the next date of August.
Deeply obliged.
My child.
Okay.